think we're gonna present sitting, actually.
Really?
Because they taped the microphone.
Okay. Well,
So-
you can take it out, right? Oh, they taped it.
They taped it, yeah. So I don't think you can take it out, actually.
Okay, good afternoon, ladies and gentlemen. I'm using mic because today we are broadcasted. So I'm very happy to welcome all of you in this workshop organized by ECTA. This time we are focusing our forces on copyright issues, and someone before the workshop asked me why ECTA is covering copyright, because the title is European Communities Trademark Association. So, since already many years, ECTA broadened its expertise, and we are covering also designs, geographical indication, and since a couple years, copyright. We have established a copyright committee, which is very actively work and following copyright issues. Copyright topics are including in our sessions in the annual meeting, and we are happy that we are managing to organize also workshops relating to the copyright issue. Today, workshop will be focused on update on the EU copyright reform. This will be the first part, and the second one will be the update on the recent case law relating to communication to the public. So the moderator of both parts will be Fabio Angelini. He is a well-known person at ECTA, but to those who are not so well know him, he is a council member of ECTA. He used to be a chair of law committee for many years, and now he is co-chair of copyright committee. He is working with Simone and Partners in Italy, and he is an expert in copyright issues, frequently speaking about these topics in ECTA events and other ones. So I am happy that Fabio agreed to moderate this session. Also, we have a panel of excellent speakers. So Fabio will introduce with both of them and then afterwards with others. So I'm happy that you accept our invitation and come today and share your experience with us. I encourage you ask questions as we are also online. So those who are following us online can ask the questions also. So I welcome all of you, wish you a pleasant afternoon, and pass the floor to Fabio.
And welcome to everybody. Does this one work? Is it working? Okay. I'll say a few words before starting and giving the floor to our great speakers of today. And these are a few notes that I put together to introduce the today workshop. We are in a very exciting, but also scary times. And the EU is trying to reform the copyright law after many, many years. And as you know, the main text was issued back in 2001, so almost 17 years has passed. And it's part of this wider strategy to create what they call the digital single market, where all 28 now, but it will be 27, unfortunately, very soon, and it's going to be interesting to see what copyright issue will be dealt with in the framework of Brexit, and I think that this might be a great topic and great discussion to have, and maybe some other workshop, because we know that England is a large player in copyright issue. We know that one of the largest television, if not the largest European television, is Sky, which is based in England, and it will be interesting to see how England and the European Union will come to terms in copyrights, because if you think to that, I mean, this digital agenda was made in a framework in which England played a large role. And the copyright issues are being dealt in the framework of a directive, which, as you know very well, are not immediately applicable in member states, but they will have to be implemented. We still don't know what are the terms of implementation of the directive, the new directive, but most likely they will be after that the Brexit will have taken place. So it's interesting to see whether or not the UK will implement this in part of the acquis communautaire. I don't know, because it seems that they are doing this big repeal law, and we don't know what kind of copyright terms will be introduced. So it's interesting, but let's forget about Brexit for now and leave it. So we know that already this agenda, which is being pushed by the Commission and the Parliament on the digital single market, has reached some objective. We know that an agreement has been reached on the geoportability, and this is something that will be also discussed a little bit later. We know, for instance, to the big, I would say, happiness of our young generations, that roaming fees are no longer applicable, so you can use your telephone all over the European Union without having to pay absolute roaming fees. And again, it will be interesting to see whether or not when you go in England, you will have to go around with your wallet stack of money. But apart of this, we still have the big one. And the big one is the draft proposal for the digital copyright reform, which, as we know, was published last September. And since then, we have been discussing, and there have been lots and lots and lots of arguments over on the one side and on the other side. Now, as perhaps you know, we were supposed to have a very competent speaker from the European Parliament, which was Ms. Julia Reda. And she's one of those that's very much into these kind of issues. Unfortunately, she cannot be here. And therefore, I thought that maybe I could, if not replace her, at least voice some of the concerns that Ms. Julia Reda and some in their, let's say, political views are expressing. The problem is that the European directive, as it is right now, poses some certain fundamental questions which basically put together two different kind of issues. And the two different kind of issues are, on the one side, the need to protect and properly reward the creators of content. On the other side, there are also the interest of a wide numbers of subjects which may find themselves in very troubling waters if some of these provisions are not adequately, let's say, if we are incapable of finding definite answer to the fundamental question, which is how to balance individual rights, right to privacy, right to have your content uploaded into internet without being attacked, without being sued, without being hampered in your creation of other original content. As long as content was only supplied by certain individual subjects, maybe film producer, music producer, content producer, which were established in a corporate form, it was pretty easy to organize the exploitation of the rights. But when you move in a situation in which individual users upload their contents on platforms, then the question arises, and who is responsible and who has to take care of making sure the rights are not infringed, if rights are infringed at all. So, on the one hand, we have another big problem. And the big problem is that if you look at certain articles of the Copyright Directive, we have, and I don't want to talk about the Big Brother, but I will move to another book of George Orwell, The Animal Farm, that all animals are equal, but some animals are more equal than others. And if you look specifically to Article 13, and you will see that there is this particular provision that says that those who handle large quantity of data may be responsible for certain kind of conducts, which include enforcing and controlling the content in order to protect copyrights. Now, we all know, without being overly cynical, that these large quantity holders of data are not very difficult to identify. Normally, laws are applied and are applicable and should be made to provide a solution for all subjects being considered equal. But we all know that all these platforms come from one side, the other side of the pond. They're all American companies. Do we want to name them? Facebook, Instagram, Google, YouTube, whatever it is. They're all Americans. So the large quantity are all Americans. So we are having a particular rule which only applies to certain subjects. And we cannot but agree on the fact that while it is true that these subjects do handle large quantity of data, then you think, it is possible that this is happening because in Europe we have been unable to create companies which are as much as capable of handling large quantity of data, and therefore it's much easier to impose our rule to subjects which do not fall within our jurisdiction, like they are the large quantity data holder which are across the pond, simply because we don't have anyone here in Europe which has been able to create this kind of very successful company and enterprise. So that's my first observation. The second observation is that there are a lot of companies which do rely on open platforms. For instance, all those who are developers of software. They do live in an environment which is largely the result of contribution by a large number of individual users. These kind of rules may impede the practical functioning of these platforms. I can make another and final example. There are a lot of startups, and a lot of these startups do live and thrive on, for instance, the function of news aggregators. Article 11, which would extend the communication, the right of communication, also to this kind of companies for the right of publisher, may create a situation in which startups and new companies which are trying to access the digital market may find themselves in a very serious position. Why? Because they may not have the resources, the financial resources to get the level of protection which this directive may, for instance, require. On the other hand, I do recognize that there is a need to protect others that right now find themselves basically impeded from exercising their rights and to get a fair remuneration to their individual content and to what they create. And therefore, there is a necessity to balance these two different interests. The problem is whether or not we are going to be able to find an adequate solution to that. Anyway, so this is my large overview. It's my personal view. It doesn't reflect the view of ACTA. It doesn't reflect the view of the Copyright Committee, which, by the way, is preparing a position paper which will then be circulated among the Council, and if it is approved, then will be also forward to the Commission and to all other entities which are interested to hear. And these are our own comments. Anyway, after this, and after I'm apologizing if I've been bored on this, I will now pass the floor to our great speakers, and we will start with Sebastian. And I will give you a little bit of information about Sebastian because it's very impressive, and it's always good to know who is talking to you. So Sebastian Felix Schwimmer, correct?
Perfect. Perfetto.
Okay. Perfetto. Is an industrial researcher at the Danish Internet Forum and the Center for Information Innovation Law at the University of Copenhagen. So you're Danish. Sebastian is primarily interested in studying policy-related questions on technology and, of course, copyright law, digital single market, internet regulation, and is frequently speaking, and I know because yesterday he was speaking somewhere else and today speaking here, so it's always speaking here and there, on current technology and advocacy issues. And is intrigued by legal informatics and by artificial intelligence. So it's a pity that our former secretary, legal coordinator, Barbara Alaminos, she is also taking a PhD, and you know her very well. Anyway, Sebastian is one of the initiators of the CPHFTW, which is not the WTF, it's something different, no? Grassroots movement, and you will have to explain what it is, in Copenhagen Tech Fest, Scandinavia Big Selling Startup. So it is interesting what is startup, because in the same way that in Silicon Valley they were capable of having startup which then have ruled the world, I've always wondered why European companies, European startup cannot, and whether it is a problem of that there is not enough, or maybe there is too much regulation, whether or not there is not enough capital funding for this kind of thing. So basically because we don't have the same kind of ideas that they have, which I find it strange because we are not less stupid than they are. And he is working for leading law firms and advise technology companies and launch several ventures in the digital ecosystem. Well, that's interesting. So he has a PhD from the University of Copenhagen, degrees in law, economics and management from Copyright Business School, and a law from the Ludwig Maximilian University. Wow. And you play soccer.
I don't.
And he doesn't play soccer. Anyway, I give the floor to Sebastian, and enjoy.
Yes, thank you very much. Let me just adjust and my slides, if they could be full screen. Now let's see whether we can make this work. So first of all, good afternoon everyone here in the room. Thank you for the great opportunity to be part of ECTA again. And also good afternoon to everyone at home. I hope they can hear me as well. It's a little special. Usually I love to walk around when I'm talking because I find it very engaging. And I don't know, maybe I will move my hands a lot now. We'll see. I hope you won't fall asleep after lunch. So I'm going to talk a little about the EU copyright reform, or rather a topic that I find super interesting, which is the licensing of and the access to copyright protected works. And there has happened a lot over the last years on this area, and if we assume that with this latest copyright package we're done for the future, where are we at? So I'm going to have some look at that. Now let me briefly jump to the next slide, which is actually about me. So I think the introduction was copied from some old website. I should update my profile. It's not that impressive at all. But I'm a researcher. I work a lot with copyright and internet regulation. Currently we're looking, for example, at a fitness check of the Danish copyright law in relation to what has been happening both from the European Court of Justice, but also the European legislator, and some other projects on that. Let's briefly talk about the issue. So what is the issue of access to content? You might have seen pictures like this one. It's from a flight, from the flight entertainment system, and it says they can't offer extensive music onboard selection right now because of licensing issues. Or when I try to access our video, any kind of video platform right now from Brussels, from Denmark, I'm by the way German, but I live in Denmark, it would say the content is blocked, you can't access it. And this is the case for 77% of subscription-based business models that apply geo-blocking. And if you might have heard of this Norwegian TV series Skam, it's a great success for online TV program for young people. It's by the public broadcaster, and the same is there. I can't watch it outside of Norway, and that's actually the case for 82% of publicly funded models, according to the European Commission. At the same time, we've seen this increase in streaming in Denmark. These numbers are a little outdated. They're from 2015. The 16 numbers are not available yet. 72% of music revenues, for example, were accounted for by streaming. And in Norway, it's even 81% in the same time, or 83% in 2016. So with this little primer, where are we at? We have 28 member states. We have copyright's territorial nature, or rather the territorial exploitation of copyright. Article 5, paragraph 2 of the Berne Convention. And on the other side, we have the digital single market and really also the consumer demand for access, cross-border, multi-repertoire, and portable. And this is the perspective I'm going to take in this presentation. So with all those tools, if we take the Commission serious with making the digital single market happen and access happen, how far are we? This is not only demand by consumers, there might also be cases as in music with split copyrights, several right holders and publishers in different nationalities, national states, which lead to this demand for cross-border licensing. And if we think a little broader about access and licensing, there's two layers we can think of. There's a relation between the right holders and the online content services, so this licensing relation. But there is also this access dimension from the consumer to the online content service. And those two I want to take as some guiding principles through this presentation. And if we think about access, I briefly want to differentiate two situations. So if a consumer tries to access a content service, let's assume we have a content service in member state A, for example, in Belgium, and we have a consumer from that member state A, so from Belgium, being temporarily in a different member state, for example, Denmark, trying to access this service. This would be then the case of a temporary access regime that is covered by the portability regulation. The other scenario, which has to be differentiated, is the scenario where a consumer from member state B, in member state B, so we still have the content service from Belgium, being accessed by a Danish citizen from Denmark. Not a temporary element at all. And this is then what relates to this access regime of geo-blocking. And I think a good way of thinking of that, it's by no way perfect, but is if we think of the first scenario where the consumer moves of a free movement of the consumer scenario. And the second scenario is really the free movement of the service, because the service goes over a border and the consumer just stays where it is. So licensing and access in those two scenarios. The second differentiation, which I find important and which I want to convey here, is between ex post control and ex ante regulation. So on the one side, we have competition rules, competition law that apply in these areas, and legislation. And we're going to have a look at what that meant in the different areas. This is just a timeline, I hope you can read it, of the different arrangements that have been the case. I mean, the biggest takeaway is probably a lot has happened recently, saying in the last 5 years. If we go to the first part, the competition part, I want to differentiate two different situations. There's a licensor relationship, so between separate licensors. And that is, for example, the case with model contracts and territorial restrictions, which have been mainly addressed in the music sphere from a competition side of things. The second scenario, the licensor-licensee relationship, so the right holder and the licensee, relates to the licensing contracts, which mostly in the audiovisual sector have been problematic for the territorial delineation. So it's two different angles, but it's a similar or the same issue. If we look at the first one, for music, the arrangement has been that cross-border licensing was enabled by collective management organizations in form of reciprocal representation agreements. You might have heard of those before. It's basically an agreement between a right holder or a CMO in country A that represents all of the right holders from country A, and then has an agreement with the CMO of another country, which has all the right holders of country B, and then together they are able to, in their local country, have a license for the collective repertoire. This has been fairly problematic from a competition point of view. The cases Tunia, Lucaso, and then the CISA cases have been the most important ones in this case, and pointed towards that this territorial delineation is in that form not possible. The second scenario is the licensor-licensee relationship. In the licensor-licensee relationship, here I primarily want to talk about the Premier League and Murphy case of 2011, where territorial exclusivity protected by contractual obligations that require the licensees to prevent the public from accessing or receiving outside the licensed area. In that case, it was the decoder devices, if you remember. So this case was not about streaming, but it's relevant nonetheless. The court held that right holders are not prohibited as such to delineate markets geographically, but that the additional contractual obligation rationale is problematic. And that correlates to the general principle of passive sales. In 2014, then, the European Commission opened antitrust proceedings in the pay TV saga based on the Premier League and Murphy, and this can really be seen as exploring the outer boundaries of Premier League and Murphy, because the pay TV saga regards direct access by the consumers, so there's no additional restrictions, such as a ban on decoder devices, it's the direct access. And in 2016, then, last year, Paramount offered to, in one of the cases, to cease its geo-blocking practice, which was accepted by the European Commission in July 2016. So this is the competition side of things, and I think it's important to keep that in mind then for the legislative angle. And here I want to differentiate between the multi-territorial licensing part, mainly CMOs, and cross-border access. And if we look at the multi-territorial licensing part, we can see the shift from voluntary to binding measures. So there has been in 2005, some of you might have been working with online music before, an online music recommendation on making it easier to license on a multi-territorial basis. It was codified in the Directive 2014-26 of the EU. And for audiovisual content, now we have a proposal in the proposal for directive on copyright in the digital single market. If we look at the CRM situation, really this is what happened. So in the beginning, we had collective management organizations that, based on the model contracts, on this reciprocal representation agreements with each other, could license mono-territorial but multi-repertoire. So in one country, but all of the repertoire. And this has been based mostly on self-regulation national rules. Now, when this, from a competition stance, was being criticized with the recommendation of 2005 and the CZEC decision, we've seen an emergence of customized licensing entities. And what they are doing, and they're really a layer on top, is they license their catalog multi-territorial but mono-repertoire. So one repertoire, but for all of Europe. And this is kind of find its basis in the soft and case law. In the latest edition with the directive of 2016 is the implementation of a licensing hub model, where hubs should license multi-territorial, but also multi-repertoire. So going to a situation where a lot of repertoire is represented in a hub and licenses for all of Europe. The main mechanism this is built on is a European licensing passport. If any of you have been working in the banking sector, the European Commission sometimes plays with passport models for author CMOs, and the goal is to encourage a reaggregation of rights in those hubs. And there's two main legal tools for that. The one is that there's a certain capacity for CMOs that you can process multi-territorial licenses. And the second one, the second mechanism is a take-on obligation, a take-on opportunity for those who don't, so that everyone can enshrine their rights into one of those hubs. So this is built on two main incentives, I think. One, risking right holders to withdraw if you don't offer multi-territorial licensing, and an incentive for some few licensing hubs, so decreasing transaction costs in that process, basically by market forces and compliance costs. In the current directive proposal, in a very, very short chapter, Chapter 2, on access to and availability of audiovisual works on video-on-demand services, there's a negotiation mechanism in Article 10 of the proposal. The chapter actually has only Article 10. I don't find the negotiation mechanism too interesting. Basically, it would establish that member states should ensure where parties wishing to conclude an agreement for the purpose of making available audiovisual works on video-on-demand platforms, when they face difficulties with the licensing of rights, then they may rely on the assistance of an impartial body of relevant experience. So this is, for the audiovisual sector, a negotiation mechanism that could come in place, but not much more. As, for example, I think there's a French example of an obligation, for example, on the continuous exploitation. Switching sites, so this is a licensing part, the one layer. The second legislative perspective is on cross-border access, and I think this is also really interesting. We have the portability regulation of 2017, which was published in June this year. The geo-blocking proposal and the broadcasting proposal. The first two I will talk mostly about. So for the portability proposal, portability, if I may remind you, it's a situation where a consumer moves temporarily in different member states, so where we talk about the free movement of the consumer, has a very interesting and intriguing legal mechanism, and it works the following way. An online content service provider needs to provide a consumer that is temporarily in a different member state access to its service, and the facilitation mechanism behind is that in Article 4, this access is deemed to occur solely in the member state of the consumer's residence, so legal fiction. Any contractual obligation that runs opposed this would then be unenforceable. And all in all, this is a really sleek and fairly simple mechanism. What is interesting is that it's obviously very restricted in scope. It only regards situations where somebody is temporary in a different member state. Another observation is that it mainly covers paid services. There is in Article 6 a possibility for online content services that offer service without payment of money to enable this mechanism if they have the licenses. The second regulation, which is still being a proposal, is the geo-blocking regulation. And the geo-blocking regulation covers many different things, and copyright is really just an auxiliary aspect of that. In Recital 6, it differentiates between audiovisual and non-audiovisual services, and the regulation applies to non-audiovisual services with the exception of Article 4. And Article 4 is the access to the services. The interesting point here is that audiovisual services are completely exempt from that. There's a review clause in Article 9 that sets this for evaluation after 2 years. So whether copyrighted services, the main feature of which the provision of access to and use of copyright protected works is, apart from audiovisual works, should be included, but not for the audiovisual part. There has been some debate on this. The Committee on Industry, Research and Energy, for example, suggested the deletion of the restriction on copyright in Article 4. The IMCO report of April 2017 also foresees an expansion with a new addition which says where the trader provides electronically supplied non-audiovisual works or services which main feature is copyright, provided that the rights have been acquired for the territories. Right now, this is in the trialogue. I don't have any newest updates. Maybe some of you have. So the open question really is to what extent will copyright be part of the geo-blocking regulation or not? In the current proposal, what I think is also interesting is that there's this differentiation between music and other forms of copyright and audiovisual copyrighted works. And for the non-audiovisual works, it's only Article 4 that is being excluded. So that means that, for example, the access to the interface, which is provided for in Article 3, is available. Access to the interface could be the website. So that could mean that you can go on a website in another country and see, oh, Spotify is cheap here, but you can't access a service as such. So that is on geo-blocking. Now I want to conclude with some bigger rationalization of the current regulatory framework. So first of all, the regulatory framework is fairly complex because it operates on so many different levels with so many different subject matters and institutional arrangements. For multi-territorial licensing, so the one part of this picture of how access can be broadened, in a cross-border world. Mitigating transaction costs as a means to increase access to repertoire has been the primary means. For cross-border access, on the other side, we've seen a fairly ambitious approach by regulations, which hasn't been applied in copyright-related fields before, which, however, are much less ambitious in terms of the scope they cover. For the licensor relationship, so we think about licensing and mainly about CMOs here, it is very clear that over the last 15 years, territorial restrictions have to be reviewed in the licensor relationships. It's also being seen that the classic or traditional economic efficiency argument is being eroded in the digital landscape, and that the competition between CMOs has been chosen as a means to broaden repertoire access. If we look at the other side, the regulation of cross-border access, I think the portability regulation offers a really intriguing model because it's a very sleek mechanism that we've seen in other areas before. Whereas the true cross-border access, so the situation where we access a content service from another member state and are not just temporarily in another member state, is still being very open, right? It's being exempt from the proposal as it stands. The question is whether it will be included. So if this would go through as it is, it wouldn't be addressed properly in the framework. And even Article 9 on the review clause 2 years after wouldn't necessarily change that. However, I think there's this really intriguing thought of play with the Premier League and Murphy case and the pay TV investigation, which points towards a broader application of the passive sales rationale. In this context, it's important to note that with passive sales, service providers wouldn't be obliged to respond to, but it's at least an opportunity or an option that competition law will open this form of access. I find this quite unsatisfactory. One, because the direct contractual relation between the services and the consumers is being unaddressed in a way. And in a world of streaming, where this is really kind of the primary means of the access control to copyright-protected goods, it might be a little tricky to leave that up to case law to decide on how we move on here. There's also a really, is this the right? Yes, it's the right slide. There's also a really interesting interplay or double approach at place here. So we have on the one side traditional competition law being applied, on the other side regulation. This is both on an institutional level, so between DG Comp and the other DGs. And it feels that competition law can be used, or is being used actually, to ensure access to copyright-protected works. So there's, on the one side, competition law and legislative intervention support each other. And it's necessary because you need to clear the underlying rights. But there's also still some open questions. This also seems to be a somehow well-tuned interplay, to some degree at least, from the Commission. And competition law really here is helpful in mitigating some of the effects on territorial licenses. Now to conclude, to me it seems that competition law is, or more as a statement, competition law is taking back some of the autonomy that copyright-protected subject matter enjoyed in the offline world. And I think also with the current proposals being out there and assuming that that is the kind of updated copyright we have, this is we might see more in that. And a second thought is that we have this move towards a copyright consumer perspective in access to copyright protected works. So there is, with the regulations, a clear shift in what we look at and what the Commission is focusing on. One thing in this aspect, which is still kind of the crucial question and not really being addressed, is kind of how do we limit contractual freedom? Is that what should be done or not? And to conclude, I think any measure really must not only solve the underlying licensing issue, which is why I also have these 2 points, right? Licensing on one side, access on the other, but the access dimension as well. And in a streaming world, the access dimension is largely dictated by the terms of services of the online service providers. So both of those need to be addressed. This is all what I have for now. To conclude, I think the proposals are interesting, but they're all just bricks in a bigger picture. The proposals, if they would all be go through as they are currently being proposed, they wouldn't solve all the issues. And there's still competition law, which I think is important to reflect upon if we think about access to copyright-protected works in a cross-border situation. Thank you.
Thank you, Sebastian. I have a couple of questions. The first one comes exactly from what you just said. So the big interrogative is integration. Mm-hmm. So how is, and whether or not it is possible to have an integration between geoportability, between blocking. It is your feeling that the Commission and the Parliament and the other stakeholder are trying to address these things in a comprehensive way so as to integrate, or do you think, and this is my question, or are they going on separate ways? And are we sure that they are all going in a way that sooner or later we will have a digital single market? Because this is what we are talking today, a digital single market, in the same way that when they were doing, for instance, financial regulation, they tried to address all aspects so that we would have a common and uniform financial market in which consumer could go and open an account in one country and move their money, and it didn't matter whether they were from Italy, from Denmark, from Germany, from Spain, so what about integration? So that's the first question.
Can you specify a little integration in what respect?
It seems to me that from what I read here, so we have a regulation on cross-border, we have a regulation on geoportability, and we have another regulation, and then we have competition. Do you think there is an effort to try then to bring them all together? Is it possible to bring them all together? Or they are going on separate ways and someone is going a little bit forward, another one remains behind, and then there is some aspect that is being forgotten, and that will be part of the second question that I will do.
Yes, so I mean, first of all, obviously this is a measured, or all of these are measures that in their ultimate interplay should promote integration and should kind of reflect the digital single market while balancing, and my presentation was very much from an access point of view, so a very consumer, or rather taking the Commission for what it says, that we somehow want to establish cross-border access in Europe for a system which is still very much based on territorial rights and territorial exploitation. And I think the proposals do not really reflect on that in a sufficient way. So instead, it's very different pieces of the bigger picture that are being addressed. I mean, the portability regulation, which is a very beautiful, I think, mechanism as such, is really only working in that area realistically. So there's kind of a piecemeal approach on different aspects of the same question. And I'm not sure whether your question is like, is this a sufficient approach?
Yes.
I'm not so sure, right? It would be definitely important to see a more concerted effort. I think there's been quite some confusion as to the interplay of the portability regulation and the geo-blocking proposed regulation. Also, the open question how much copyright is should even be part of the geo-blocking regulation. And I don't know how many of you have read the geo-blocking proposal, but it works in a very different notion that we're usually used to in copyright, right? It talks about traders. It talks all those aspects come from a very different world than the traditional copyright world. So it is kind of coming through the back door via making the digital single market work in many areas, and then bringing copyright in there maybe halfway. I'm not sure this is totally sufficient.
Okay, and the second question is, do you feel that there is something missing, and it's an appreciation of what reality is? I want to make an example. We all know, we were talking about streaming. Now, streaming is beautiful, but you need to have signal in order to have streaming. If you don't have signal, if you don't have access to internet, you cannot get streaming. So what is the answer? Very simple. You can download your show so you can watch it wherever you want, wherever you want, no matter how many times you want. Very simple. How many times have you seen people that maybe are in a beach and it's the middle of nowhere, and you can see them, they're on their phone and they're watching a movie or something like that. In order to do that, however, you need to download this. And a lot of times, companies which do the streaming don't have the rights to allow the downloading of their content. And yet, and this is something we were discussing before, the true cross-border access. The true cross-border access is this, the possibility that you can download your content and you can watch it wherever you want. Because yes, I can go in another country and I can stream. But what is the difference if I want to go in another country and I want to have the content downloaded so that I don't have to stream it, I have already there, if I don't have signal. So is this in the current regulation? Do you see any of the effort to go look at what is the model in which the market is going? Netflix is going this way. This premium service, we were talking about Norway, we're talking about, it's not casual. There are these countries because these are the countries where you have the largest access to high-speed internet, because of course, again, you can always streaming if you have high-speed internet. If you have an internet goes very slow, you're going to die before you're able to look at any streaming. You're going to stop and buffer every 3 seconds. So one of the things is that the downloading of the content, then you go into the copyright, then you go into the licensing. Is there anything about that you can see?
I mean, first of all, downloading and streaming are very different for what rights they need, right? And that was also a brief introduction I tried to give. Streaming is very much what consumers are using right now and preferring right now, and I think that's the reality we're facing, the reality that should be kind of addressed and solved.
I'm looking forward. You understand? I mean, today is streaming, tomorrow is downloading, and the content with you in any moment. One times those little things could only have like 10 giga or 10 mega and then become 10 giga and then maybe you're going to have 1 tera and maybe a 10 tera, something like this, and so that you can put over there the entire content of human knowledge.
But I think right now, I mean, and I'm really not the expert to say that, but I think, I mean, right now it's very clear that we are talking not anymore about owning, but about accessing. And that's the reality that we face, and somehow is being addressed by the current proposals in one way or another. I think you asked before, is something missing? And I think the missing link is, first of all, there could also be some more fundamental questions about copyright and the copyright regime as we have it, right? Digital exhaustion is one example that might solve some of the issues of access. And again, this is very much an argumentation for if we want cross-border access in all dimensions, then some of those things need to be adjusted. The other aspect with this patchwork, I feel if you take the portability regulation is obviously a very nice tool. It will enable us when we're traveling to access different kinds of services. Together with the broadcasting proposal, it might actually even enable us to access some of our public broadcasts when we are traveling from home. But it's just a very limited use case in reality of the digital single market. And if we take the Premier League and Murphy case, I think a lot of scholars have been assuming that this rationale could be expanded and being used in a broader fashion. And I would argue that still the passive sale rationale is very intriguing to use in this context, but it's not being addressed in the current proposals. So there's definitely something missing on those parts.
Which was I? My conclusion as well. Okay, thanks. We will have a question and answer later on at the end of the session, because now we have to move to Martin.
Shall we switch?
Yeah, we're going to switch. Yes, you switch. I'm going to introduce you quickly. Martin is another academic. He's an assistant professor at the Tilburg University in the Netherlands. So you are Dutch?
No.
No. So he's not Danish and he's not Dutch. Anyway, appointing John So where are you from?
Slovakia.
So he's from Slovakia, okay. Jointly appointed by the Tilburg Institute for Law, Technology and Society and the Tilburg Law and Economics Center. And he's an affiliated scholar at the Center for Internet Society of a college which is always being severely trashed by my alma, UC Berkeley, go Bears. Yeah, because he's from the Stanford Law School. So, and then as you may know, between Berkeley and Stanford, there is this long-standing football, no? And there is, it's one of the highest peak of stupidity in the Bay Area. And he's a great one because he has obtained his PhD. I'm impressed from the Max Planck Institute for Innovation and Competition Law at Ludwig Maxim University in Munich, for his work on injunction against intermediaries, which is something we are not making any kind of advertisement and commercials, but if we have to do, we have to make like ping, so that now it's moment for promotion. It's a forthcoming with Cambridge University Press, and you will see it after, and I recommend you to buy when it comes out because it's a very interesting book. Now, you're going to talk, I hope so. Anyway, you're going to talk about the copyright reform platforms, which is one of the hottest of all.
Okay. Hello, everyone. Good afternoon. I hope this works well. Well, first of all, thanks a lot for having me. And, well, thank you very much for your very kind introduction. I actually didn't coerce him to say that. It was not coordinated. But thanks a lot for promotion. So I'll be talking about platforms today. You're all aware of the developments in Europe when it comes to platforms, and we'll talk a little bit about that. I think it's also interesting for trademark people because it's as you know, currently there's a split for copyright issues and non-copyright issues, and things that are about IP enforcement in general, excluding copyright, are sort of stuck elsewhere, let's say. Let's put it this way. So you can answer for yourself whether we can expect something similar also for, say, trademark owners, as we have now in the proposal for copyright. But that's, of course, something we'll see. Okay, so let's start. I think it's a maybe good way how to start is to give sort of a very helicopter view of state of affairs. So where we are now at the moment, what is happening before the court, and then we enter the reform and discuss a little bit about this provision that the European Commission proposed.
And you can use a drone.
Yeah, sure. So you don't have to use helicopter these days, but it can be drone view as well.
See how technology changes.
But I wanted, I wanted to accommodate people so they can join me in my helicopter. So, so welcome. So this is my view from the helicopter. You see that this is the timeline. 2000, we had the e-commerce directive, then 2001 InfoSoc directive, 2004 enforcement directive, and so from 2008 we have like a first cases on IPR enforcement, Pro Musica and all the cases that follow later, and then we have 2015 public consultation run by the European Commission about how the new rules should look like, specifically asking also about platforms. And then, of course, 2016, end of August, leak of the proposal by the European Commission, then followed by the actual proposal. So as you know, I won't be going into this, but all these pieces of a puzzle are dealing with something else. So ECD, e-commerce directive, is dealing with safe harbors. InfoSoc directive is dealing with, to some extent, limited extent, with remedies. In particular, what is of our interest here is 8.3, which deals with injunctions. Enforcement directive dealing with remedies in general, including limits on remedies, Article 3. And also with Article 11, third sentence, which deals again with injunctions against intermediaries. also disclosure against intermediaries, information claim, etc. So that's the kind of a framework. Now, one of the things that we see, and that's a sort of ongoing debate and question, is how the pieces really fit. These are different pieces of legislation. They usually come with the same magical sentence saying, without prejudice to, which basically in the EU speak means, well, these pieces of legislation don't touch. So strictly speaking, if you have this piece of puzzle, they should sort of fit into each other. Where when they have some tensions, they should somehow nicely fit into each other, because there's assumption that there is a coherence between these two laws. Because if there is no coherence, then what you're saying that the later law probably modifies the earlier law, or what you're saying is this is a specific situation where the specific law amends the previous law. And without prejudice clause usually says there's nothing of the two. It's completely next to this legislation. There is no tension whatsoever. So what you have to deal with is basically have different parts of law, different instruments that try to achieve something, and there is sometimes a question, how do they interrelate? And the same story will be also newly proposed DSM directive, which again will add additional fourth piece of puzzle to this jigsaw, and we'll have to figure out how that interacts. And there's a lot of disagreement, of course, on how that looks like, what's the outcome. So, the question today, and this is many people were discussing, is are these pieces really fitting into each other, or are they rather in conflict and we're just sort of trying to find our way in making them look like they're in harmony? Now, of course, one of the things that people sort of agree on is that if you perceive these things as a piece of puzzle and then the resulting puzzle is actually how we regulate online platforms, we have this one piece that is always missing. And this one piece is the secondary liability in tort. So basically these national doctrines in tort law, or sometimes also specific doctrines in copyright law, trademark law, that regulate how people who are not themselves infringing could end up being infringers, or let's say wrongdoers, by basically helping out other people, aiding and abetting their infringements without themselves implicating themselves in exclusive rights. So this is the piece of puzzle that we all kind of realize it's missing, right? And the Commission knows that, we all know about that, in the context of the unitary patent court system. There was also discussion, and some people proposed that we should also include that if we want to have a common European patent system. But somehow there is not that much interest in picking up this. Maybe because it's too contentious. I don't know. In any case, one of the things that we see is that this piece of puzzle is missing. Secondary liability in tort is basically missing. And we have safe harbors that prevent liability, but if you miss the safe harbor, or if safe harbor is not applicable to you, then there's nothing establishing liability. It's all domestic laws. Now, what are the realistic options that we could deal with here? So what is on the table? So one of the ways that you can approach this is to do nothing. That's the for the policymaker the safest approach. So what you can do is you say, well, this is unfortunate, but that's the matter of life. There is no political will, so we don't do anything. Also for the court, because of course we're not only talking about the European Commission, but also the court itself, can also adopt approach where it says basically, no, I have nothing to do here. It's clear that this area of law is not being harmonized. I won't be doing anything in this area. And I will, anytime someone asks this question, I will just say back, well, this is a question for the national law to determine. So that's one approach, and up until now, this was basically the approach adopted by the Commission. When it comes to the court, there are many cases and many opinions of advocate generals where basically there is acknowledgement that secondary liability is not being harmonized. So this is where it's Laurel and eBay, where it's many opinions of advocate generals saying this area is not harmonized. The latest is, of course, the McFadden case, but there are many of these cases where basically advocate generals are opinion. I think I counted it something like five different advocate generals said that in the past. But this is not really. This is one of the ways, but this is also not a full explanation of what is going on. So when you look, the other approach is for the Court of Justice to become an active player in the game. So a court of justice could say, well, I realize that this is a missing puzzle, but maybe I cannot fully fill the puzzle. I cannot completely cover the space, but I could maybe, somehow venture in some of the areas. And, this is what we see to some extent, to the dismay of many academics who are sort of very unhappy about this. And where court, especially in copyright law, it's sort of spoiling our old understanding of how exclusive rights are being drafted, and basically injects these new criteria such as knowledge and, just to be able to regulate also through direct infringements, which are harmonized, also areas that were previously considered to be in this domain of non-harmonized secondary liability. So this goes both for linking, goes for this, the Pirate Bay case, and this is probably one of the areas in copyright law we'll see much more of this. Whether this covers the entire area of secondary liability is the question. We don't know, but you can clearly see this trend that a court is venturing into this area to sort of fill in the gap, because they don't want to answer the Pirate Bay. It's legal from the standpoint of the union law, and it's up to the national law to determine whether it's illegal. So you rather want to invent something to say that it's illegal also on the union law level. So this is one of the ways. Of course, there's a different way how you can approach this, but GS Media also implicitly was one of the ways, was one of the cases that kind of rejected that. So court could have taken a different approach. Namely, it could have invented its own doctrines of secondary liability, right? So it could have said, well, this is uncodified in most other countries anyway, so let's look at the common legal heritage in many countries and let's come up with something which defines who the contributory infringer is, etc. Now, there are some signs that this could have been attempted maybe in Donner case. There's one case about cross-border distribution. But this case was never followed, and as I say, GS Media was a case where one of the governments, in that case was Slovakia, was actually suggesting to the court, don't expand Article 3 of the InfoSoc, so communication to the public, but rather develop your own secondary liability doctrine, and the court didn't go that way. So you can see it as an implicit rejection of that approach in that case. Now, of course, this is one of the ways for the court to get involved, but that will probably never cover the whole space. Until then, of course, we have injunctions that are also applying to non-infringers that sort of serve the space on the union level. Of course, the third option is that finally the European Commission gets involved. And of course, the EU legislator tries to intervene now, but only specifically for the copyright. So this is the proposal that we will discuss in a while. There's, of course, another piece of legislation that could maybe do something in this area, which is Notice and Action Directive that might maybe also be on the agenda in upcoming months. So what are the approaches for the legislator? So the legislator could take two approaches. So one approach is to basically fill this puzzle in general, so basically design this puzzle and finally say in exhaustive fashion what the secondary infringers have to do in order to be liable in tort. So they also bear all the consequences, including damages. So that's one way how you could approach this. The problem with that is that there's a lot of disagreement on how that should look like. So there's a lot of agreement and that intent-based inducement or intent-based contribution is something that we should outlaw. But, if you go to negligence, there's a lot of disagreement. So, probably because of this, and it will be hot potato, you don't want to touch that. So what the Commission decided to go for is to go for very sector-specific solution that tries to actually even solve a sub-part of issues in the ecosystem. In this case, they didn't decide to solve all the online infringement cases, but actually decided to solve cases, or attempt to solve cases of platforms that have a lot of information from the users that is copyright protected and might act as a substitute, that's the argument, for streaming and causes the industry to lose some money. So that's basically the approach that the Commission took here. So, and that's Article 13. So what can we say about this reform? And let's have a look a little bit about this reform and its design. And I'll try to be, a little bit not bringing my position here on what I think is Article 13 is a good thing, but just looking really from purely legalistic point of view. And whether I agree or disagree, what will we do with this once this becomes a law? Okay, so as you know, the Commission in Article 13 proposed notice and stay down, what is being called by many many right owner groups. Basically, the idea is that if you want to enter the market, and there is a specification of how do you provide your services, if you want to enter that market, then you basically have to have, by default, you have an obligation to prevent availability of third-party cooperated works on your service. It doesn't apply only to copyright, but also to related rights, something there is not that much debate about. But basically you have this obligation, this very generic obligation to prevent availability of works uploaded by users if they're infringing. Now, both of the proposals, because it's kind of contentious after Sabam, to say content recognition technologies are something we want to endorse. So it's kind of in the Commission's proposal is more explicit, but in the Council's proposals, it's now only in the recitals that they mentioned that there should be, for instance, one of the ways how you can prevent availability of the works is to use content recognition technologies. But basically the agreement is that, you know, content recognition technologies, as long as they qualify for further things such as proportionality, should be endorsed. Now, what is the nature of this proposal? It's kind of interesting. In the originally proposed Article 13 by the Commission, which was MES, of course, it was hard to say what that actually was saying, and we were sort of trying to understand. Council's proposal is much clearer on what the intentions are. But what we see is that it's a standalone obligation. So this is not a sort of exclusive rights-driven thing. It's a standalone obligation that is, of course, related to copyright. But we don't know what happens if you infringe that obligation. It's absolutely not clear whether the outcome is that this is a copyright infringement. Actually, in the previous proposal, so in the Commission's proposal, there was no reference to sanctions whatsoever. Now in the Council's proposal, there is just general reference that there should be effective remedies. But this can be implemented in many different ways. So, you know, some of the member states can say, well, this is a sort of a copyright infringement-alike kind of thing. So you have a private remedy, such as injunctions, to enforce that. But in other countries, they can say, no, this is some regulator who will look at that, and they can impose fines. So it's absolutely not clear how this will be specifically enforced, whether the enforcement directive will apply. And one of the interesting bits is actually whether this will be branded as an IP obligation, because if this is an IP obligation, then it falls outside of the e-commerce directive Article 3, which deals with the country of origin principle, which allows, if there is a cross-border provision of services, to moderate on the basis of what is the law in the country of residence of the platform. If this is an IP obligation, then you cannot moderate it. So that's kind of an interesting open question. I guess the outcome would be that it is probably an IP issue, so hence it falls outside of this. But, you know, this is absolutely not clear, and we don't really know. What I find interesting is really whether the enforcement directive would really apply to this, since we don't know whether this really is an IP infringement, strictly speaking, or whether this is just a regulation on top of a copyright market. Who is the addressee of this? Of course, you know from the political campaigns that the addressee is YouTube and the likes, who are claimed to deliver to right owners, according to IFPI's estimate, 18 times less than streaming services. Of course, you should also look at methodology. I think they're certainly delivering less. That's for sure. Whether it's 18 times, I'm not so sure. But in any case, there is a case that these platforms, de facto, by falling back on safe harbors, are basically able to exploit works and then basically just pay to the right owners less. And who are these platforms? And this is the identification that is provided by the Commission and the Council. Internet Information Society Service Providers, so that's the legal term coming from the e-commerce directive, which store and provide access to public. And then there's the qualification term of significant amount of protected content. That's the Commission, that's the European Council's proposal, and or large amounts of work. That's the Commission's proposal. Whether that's really a shift in meaning, I don't know. I leave that up to you. But the idea is that if you're a bigger player, whether that will be really the outcome, that only bigger players have this obligation, I doubt, because You know, we've seen that in other areas that when you say substantial, significant, courts usually tend to dilute that to the very low threshold. I mean, think of the database directive. You know, I think it will eventually be very easy to establish that you are under this obligation. Also because it's very difficult to know how you will actually calculate that. So, the Commission's proposal doesn't really say how you should establish whether there's a large amounts of protected content. The proposal by the Council says, well, we should look at a total number of files that are generated by the users that is protected and compare that to the overall content that is on the platform. Of course, the fallacy there is that you are able to do this easily. Because, you know, you have to figure out what is protected, what is uploaded by users that you could do, and then you have to compare it to the overall. So, you know, that exercise won't be that easy, I think, in particular because the Council proposal, and Commission's proposal, this is not present, Council proposal comes this with interesting proposition that if there is a platform that mainly hosts the content that is uploaded by right owners directly or is authorized by them, these platforms shouldn't be under an obligation. So if you're a platform, say, I don't know, just think of YouTube clone, and you have a lot of content that is coming directly from right owners, then the question is whether that is mainly, you know, that content constitutes mainly, and if it does, then maybe you won't be under an obligation to introduce this, but you have to figure out how much that content is present on your platform, how much content is uploaded by people who are not considered to be right owners, because keep in mind, the user-generated content it can be, is also uploaded by right owners, so if there is some mashups, those people are also right owners. They have copyright on the mashups. Even if they infringe by those videos, they are still right owners as well. So, you know, there's kind of interesting.
Can I just think about YouTube. Mm-hmm. In YouTube, there are hundreds of channels which are uploaded by right owners.
Right.
Huh?
Yes.
You can go there and a regular channel, and it's been Disney, it can be Fox, it can be ESPN, it can be right owners. So right. YouTube does not only.
The channels are a separate issue. I don't think the channels are relevant to this discussion.
Okay, could be.
It's an opinion which is good as many opinions.
Well, we can definitely get there. Yeah. I'm really curious to hear because I think that is probably the intention. I think that might be the intention. The problem is where do you find an anchor in the law? But let's go there in the discussion. I think that's something definitely we should discuss. So so one of the interesting bits is also, if you think about this, is it's the uploaded and authorized. An interesting bit is if we are trying to exclude the uploaded content or the legitimate content, the question is why there is not a carve out for legitimate content that is not authorized. You know, there could be exception-based content that is not authorized by the right owners for the obvious reason because exception-based content doesn't need authorization. Question is why that is not there. So if you have a platform that mostly hosts legitimate, so more than 50% is legitimate user-generated content, and say the rest is 40% or 50% is illegitimate because it goes beyond the line. Why those platforms then? So it's kind of interesting debates you can get into if you think about it. You know, this is also in the Council's proposal. I don't think, you know, it's completely clear how that really fits into the definition, but that's, you know, something to be worked out, I guess. You know, things are in recitals and tomorrow they can be in the text, so as it's very often the case. Okay. One of the things that I think it's very little discussed until now is that how this will work for neighboring rights or some copyrighted works that we don't think about that often, such as computer programs. So one of the really interesting debates is what will happen with platforms like GitHub that host a lot of projects that, you know, can have compliance issues, license compliance issues with open source licenses that it's really impossible to figure out whether there is an infringement or not. And, you know, there can be really interesting debates of whether you can automate those kind of infringements. Neighboring rights not even mentioned, right? Because there you don't have an objective standard of whether something qualifies for protection or such as originality, but you can have things that, you know, by mere investment are protected, whereas to know whether something is protected or not depends on a back-end investment, and you don't know the back-end investment until the right owner comes to you. So there are open questions. I really don't know how this will work for neighboring rights. You know, will you filter sounds, or this is really an open issue. But let's walk further. So if you look at the proposal, the way this is currently drafted, so in the Commission's proposal there is not too much discussion of to prevent availability, how further that should sort of happen. The Council is more specific on that, so it says that a measure shall be applied at the request of right owners to specific other subject matters identified by right owners. So this is no change also to Commission's proposal, because Commission proposal also makes sure that there is a first step that needs to be taken by the right owner. Interesting thing here, it says that it's certain specific subject matter, which basically says it should be, you should specify your repertoire, and for repertoire, so basically for specific work or protected subject matter, you should say that this is the one that you'd like to enforce. The interesting consequence of this, I don't know what they thought about this, is that you will basically signalize to platform only on the work level whether something should be subject to stay down or not. In other words, you cannot distinguish on the use level. You know, you cannot say that parodies beyond what is legal are okay, but say, you know, just music by itself, it's not. So they will, from this, they will have to decide on the work item level, not necessarily on the use level of that work. But, you know, if there's willingness, they probably can work it out. So then the Council's proposal says that a measure shall be appropriate and proportionate. You know, this is something that probably, even if a Commission doesn't put into the law, will probably be the outcome anyway. And then, you know, they come up with things that they should be taken into account. So they say nature of the services, the type of protected subject matter, availability and costs of technologies, effectiveness, etc. It's clear that they don't want to say, they basically want to signal that not all the platforms have to have the same thing. And of course, that's a good thing, though the question is, what will happen if you will have right owners and the intermediaries discussing, because there is encouragement that a member state should facilitate best practices, and these two stakeholders should figure that out, what is the best practice, and how much we'll see basically, I don't know, Google agreeing together with major labels on what is the state-of-art technology, and then smaller players being hurt as a consequence. You know, that's something you could very easily see, that those best practices become sort of a hotbed for anti-competitive agreements on enforcement. Something also to take into account. Okay, and of course the main thing, and this is the slide with which I will pretty much conclude, and I'm looking forward to the discussion, is the scope. So what is the scope? The law really says that you have to prevent availability. So, you know, that's as vague as it can get. And that obligation applies irrespective of whether you have safe harbor or not. So whether you're covered by safe harbor, whether you're reliable, it just doesn't matter. You know, it's a standalone obligation coming on top of your responsibilities. Now, one of the things is, what happens if this becomes the law in this wording? So to prevent availability. If you look at a current case law, when it comes to injunctions, and really injunctions are the closest you can get in the current European law to those to that obligation, because they also are imposed on providers irrespective of whether they infringe or not, and they also don't care whether you have a safe harbor or not. Now, if you look at a case law on safe harbors and injunctions, you will see that, of course, there are cases like Sabam that are being sort of shaped around Article 15. Which you can say, okay, but this proposal could amend Article 15. Well, Commission says they don't want to amend Article 15 for political reasons. If they say that e-commerce directive is not touched, then I think indeed that's the consequence. The thing is that in IP, as we can see in Tommy Hilfiger case, the no monitoring obligation is now transposed also outside of the scenarios where Article 15 applies. So Article 15 applies only when the safe harbor applies. But Article 3 was sort of assumed now role of also protecting against general monitoring. And a very nice case is an offline case against a Prague flea market, where also the court said, well, Article 3, so the limitation on remedies, prevents a general monitoring obligation. So in other words, even if this proposal is passed, I think if the enforcement directive applies to this, the court will likely embed this principle of no monitoring also in the reading of this provision. Now, what that will mean is, of course, the second question. And now this is where it sort of gets interesting in my view. You know, if really there will be no claim that we are amending the e-commerce directive and all the previous laws, then you will have to put it together, you know, as a pieces of jigsaw. And now I think there are sort of two outcomes. One outcome is that a court of justice will look at the phrase "to prevent availability" and will basically try to square it back to with the case law on injunctions, because they're also preventive injunctions. And we'll basically say, okay, what is the standard that we applied for injunctions, and this is the standard that is also acceptable for these Article 13 measures. If that happens, I think it's an interesting case because unless the court will change its stance, I think until now, the Tommy Hilfiger, the trademark case, is a case that really says most loudly that the court thinks that the specific monitor, so the opposite of specific of general monitoring is a measure which is specific, and specific measure means that it has to avoid new infringements of the same nature by the same market trader. So you see that there is this link to the infringer who has to be the same. So the infringement can be of a similar nature, same nature, but the infringer has to be the same. I think it's a pretty strong statement. Of course, we can discuss whether you think that's really the governing law or not. I think at the moment it's very I think there's a strong case to be made for this. But we can certainly discuss this. But if this is the case, it's coming from Laura on eBay, by the way. If this is the case, then the question would be whether Article 13 wouldn't end up basically just with preventing same or similar infringements from the same infringer, which translated is basically just repeat infringer policy, would basically mean that a platform has an obligation to prevent infringement from the same user again, which of course would be very much narrowing compared to what the right owners really want. If you ask me, being realistic, I don't think that this would happen because I think it's clear that Article 13 tries to send a political signal. And that political signal is that we won't stay down, which involves general monitoring. You might not call it that way. I think it's still general monitoring. But so the consequence could be rather than the court will be pushed to actually adopt a more sort of a general standard where basically prevent means to prevent similar or same infringement from any infringer, which is basically the standard now used in Germany for the local concept. And if that happens, then of course the right owners get their stay down, though the question will be how the court will square that with its earlier case law, and we can also have discussion on that. In other words, I think it's really interesting. There's a lot of uncertainty. I'm not sure that it can deliver really what the Commission wants to do, but if you look at the steps, there's a lot of things that would need to be cleared anyway. And if you want to know how the system will operate and what the court might think about it, I think the most closer place to look at is really injunctions against intermediaries. And if you're interested, this is the book that is upcoming from my pen on this with Cambridge, December or January. So you might want to have a look. And I'm looking forward to the discussion here.
Thank you. So I have my usual question, and it goes directly to the I-figure case, the C494/15, which you mentioned before, which was this case about this guy who was renting stalls in this flea market, which were supposed to be selling infringing counterfeits matter. Now, the question was that was formulated, and I actually took it here, was the question that was referred to the Court of Justice said something of this, and I will read it because sometimes it's easier to understand the question when you read it the way that it was posed. And it says, "He's a person with a lease of premises in a market who provides stalls and pitches on which stalls may be placed to individual market traders for their use, an intermediary whose services are used by a third party to infringe an intellectual property right within the meaning of Article 11 of Directive 2004/48. Now, the question is the electricity company which supply electricity to a company which use that electricity to operate engines which makes counterfeits, blah, 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 blah?
Yeah, so I think the answer is, so when you look at whether electricity company supplying a factory that is producing fake goods, whether the company could be targeted by injunctions as a intermediary services are used by a third party to infringe, I think the answer is yes, when you look at how the case law is interpreting this term, which basically is really saying you can target any service provider. It's really broad, and you will find in the book I actually specifically say that I think that that's how broadly construed this is. At the same time, I have to say I'm not so sure that the court will eventually grant that injunction. There could be, the first question you would ask is to what extent electricity company can actually disconnect you on a sort of, at what cost? I'm not so sure that in many cases this would work out, though I could imagine that maybe in some cases this would be a potential recourse. So yeah, I think it's possible, and there are tons of players who could be claimed to be intermediaries, offline intermediaries. The good case to really understand that this is possible is Fritz Drunken case. So there was a Red Bull against, trademark case again, Red Bull against one of the lookalikes. And they were suing a company in Austria, I think, that was basically filling cans for the competitor. And it's not in the decision, it's in the Advocate General's opinion, I think it was Jaskinen at the time. And the Jaskinen said, well, the company that fills the cans is not using the trademark. So, there you go. Didn't want to stretch the direct infringement test. But they said the secondary liability is something to be determined by the national law, so liability in tort. But you have this European instrument on injunctions where they could be target to injunctions. So, if there is a signal from the member of the court that a company that fills the cans could be seen as a provider, I don't see why an electricity company couldn't be at least to qualify under those terms, though still that doesn't mean that the injunction would be granted. So, yeah. That would be my answer.
Yeah, and so the question that now comes is whether or not, if you send a cease and desist letter to an electric company saying you are under notice that your electricity that you are supplying to this, but wait, it could be an electricity company, it can be a phone company, it could be an internet company which is allowing, and now when we're moving to internet, to the ISP, which is providing access to the company which is making counterfeiting and is using the internet so as to sell through an online marketplace its product. Where do you stop in this possible reallocation, constant reallocation of responsibility, not to the right owners, but to everyone else? Everyone else must come into the aid of right owners. Right owners have the rights, so must be protected. So it's like all the world must come down and help intellectual property rights owner in enforcing their rights. So everyone, police, army, the Air Force, everyone comes. I mean, there is that particular field where they're actually making the grape, which is used to make a fake champagne. So go and bomb it because it may be used after this. So it's that.
This was supposed to be a legal discussion. I would kindly ask you to be serious, because for circus we go somewhere else. So don't quote the Army, don't quote the Air Force, and stay with the directive of the legal text, please. Because we are not here for show. We are all very busy. If you start quoting the Army and the Air Force and the enforcement, it becomes a show.
My apologies.
Seriously, thank you.
My apologies.
Except keep talking about the law.
Okay. So is in your way a possibility that this interpretation may be stretched as to prevent everyone to act in that way?
Well, I don't think the European notion can probably completely target everyone, but it's very broad. It's potentially very broad, and if you're providing some service that can be used in some way, you can end up on a radar of injunction. So I was recently doing some work on standardization, and I was actually baffled myself that even a standard setting organization could be target of this with respect to patent rights. So it's really broad, but it's like the law is always the law in action. So the fact that it's possible in theory doesn't mean that someone will actually sue for that. Especially because if you sue electricity company, people might start getting second thoughts about the instrument itself and might be a little bit more restrained in their application. So I think it's not in the right owner's interest at the moment to go for too far away players, because they will probably don't get the policy that they want out of it. That's of course saying that I have some preferences how the policy should look like, but yeah. In terms of law, you can go very far. I don't think you can really get anyone, certainly not army. But yeah, it's possible as a matter of law, not necessarily that plaintiffs would go there.
Okay, we will have the rest of the discussion after the second session. On this, now we are having the coffee break so that we can relax for a few minutes and get to this. I want to thank you, both of you, Martin and Sebastian, for your great speech. Were extremely interesting, and I think that everyone enjoyed them a lot, and I would like to thank them and applaud them again. Thank you. So the question remains, the proportionality of the measures. It depends on the matter we get.
Yeah.
Thank you so much for inviting us.
If you want to go for if you want to go.
Thank you very much.
Oh, my pleasure. I thank you. Thank you. Oh, that's very kind of you. Wow, that's very kind of you. Thank you.
We will have yours at the end.
Don't worry. It's not that everything. It's because the point is always the same. You go after the deep pocket.
Yes, of course.
Sure.
In torts, you always go with the deep pocket.
Yeah, but this is, you only get injunctions, so it doesn't really always give you what you want, right? So that's the different thing.
Wasn't that the rationale behind Article 13, the deep pocket? So that you're shifting.
Well, to some extent, yeah, sure, some
That
extent.
you're
Yeah.
shifting the enforcement of the right, not to the right holders, but to the content provider. I mean, the response. So if you remember, that is something that was born out of the Chinese, the so-called landlord liabilities. Have you ever heard about that? So basically what happens is that in China there are these huge markets where you can go there and you can find any kind of counterfeits. And they know that they are there. They know that they're selling fake Rolex, fake Prada, fake these kind of things. And they provide these outlets. This was before the internet, okay? So it was very, very difficult to go after these people because you went over there and they were just stalls. So as soon as these people arrived, they packed the things and left. And they were little fish. But there were hundreds of them under this huge market. And therefore, I think it was Cartier or Hermes or something like this, actually decided to go another way. And instead of going after this, they sue the landlord, the one who was renting these spaces for them, saying, we sent you notices, we told you that these people were selling counterfeits. And you didn't do, you didn't act.
Yeah.
You were liable because you were and because we gave you notice.
Yeah.
So that was the landlord liability. That was started in China.
Okay.
And then
Then this.
this one. And since then we didn't sorry. You want anything? You want a glass for the water? So welcome back. We have a little change in the schedule because the TED has to catch an early train. So we will have Ted Shapiro presentation first, and then Leon presentation.
Can you?
Later on.
How do I remove it? Sorry.
So
I'll start give you a quick presentation of Leon. Leon is a partner of Wiggins, and he is the head of the Brussels office. And before doing that, he was with the Motion Picture Association in Brussels, always. Yeah. Okay.
But I've been thinking of changing my name to Leon.
That's true because it was so flattered. Sorry. Say again. Ted. Okay. Ted. And he's a part of 20-year experience with Wiggins in Brussels. He's the head of Brussels office. Before he was with the Motion Picture Association, here always in Brussels. He was general counsel for Europe. In addition to overseeing the operation of a multi-jurisdictional litigation and compliance program, Ted was in charge of the provision of legal services to senior MPA executives and MPA member studios related to intellectual property and the new media, collective management, audiovisual regular competition, trade, and protection. Most important because here we have people that not only are lawyers but also are authors, so they feel copyright as they should, be content creators. He published a book on copyright entitled Copyright in Information Society, a guide to national implementation of the European Directive, which I think that you will have to write now with the as soon as it needs. So when you do that, you tell us, and we will do a beautiful workshop, and we will promote.
Okay. Thanks.
And he is admitted to the bar of Massachusetts and New York, and is a registered European lawyer at Brussels Bar and solicitor in England and Wales. It will be interesting after this Brexit, what is going to happen with this, whether or not there will be a recognition of careers between us and them.
Well, I received a nice letter from the bâtonnier just last week that will allow me to transfer from the E list to the A list, so I will become un vrai avocat belge.
Right. Exactly. So Ted was supposed to speak last, but since he has to catch an early train, he is going to go now, and I leave the floor to you, Ted.
Thanks.
Again.
Thank you very much, and thanks to the ECTA folks for inviting me, and thanks to Leon for letting me borrow his name and his speaking slot. Just because you've run late, I was a little bit worried about catching a train just before 6. So I was asked to sort of do this a little bit from the perspective of the audiovisual industry, I guess because of my former job, and of course a lot of our clients are broadcasters and audiovisual producers and platforms. So I'm going to sound a little bit biased, although I am an independent lawyer, because I will be speaking from the perspective of the audiovisual industry, although I do agree with a lot of what I'm saying. And so, as I said, today is focusing on the audiovisual sector. What are they thinking about all of these issues that were discussed earlier today? The focus is obviously on Article 3 of the Copyright Directive that contains the so-called communication to the public right, talking a little bit also about the role of the Court of Justice as well as recent developments, and just to look a little bit at related legislative proposals that were referred to earlier today affecting the communication to the public right. So first, a little bit about where does the audiovisual sector come from on these issues, and then you can understand why they say the things they say, why they may have somewhat different perspectives than other right holder sectors and other stakeholders. The nature of the audiovisual industry is such that they're very reliant on exclusive rights and contractual freedom. Those exclusive rights are used to finance, produce, and exploit, as well as to protect the content. And what do I mean by finance? Well, in fact, those exclusive rights are used to get money in before any camera starts turning to actually finance the production. You sell the rights usually on an exclusive territorial basis before you start doing anything. And the producers will seek to maximize revenues in each market and focus, of course, on places where the demand is the highest and tailor the content to the particularities of each territory. They share this financial risk with distributors in these territories, and then they use, of course, the money that they earn to invest in new content. Because of that prevailing business model, which, as you can see, is heavily constructed around a dirty word called territoriality, they have issues with the proposed broadcasters regulation and, to a certain extent, the directive on copyright in the digital single market. There's also a parallel initiative going on down the hall at DG Competition that many of you will be aware of regarding the Commission's investigation into the pay TV sector, a case that was launched against Sky and the 6 major studios, all members of the MPA. In fact, the original investigation also included other platforms in the other 4 largest member states, but the Commission decided to focus on the UK. That case continues to go on with constant rumors that something's about to happen. Some of you may be aware that one of the studios surrendered and made a deal with the Commission. That case has been appealed by a French broadcaster. So this thing is going on and on, but it's very hard to divorce, despite what the Commission says, from the draft legislation. And it's all about communication to the public and who's doing it and where you're doing it and what law applies. And on the enforcement side, the focus of the audiovisual industry has always been about what we call structurally infringing websites, sites that are designed with only one thing in mind, and that is to distribute content without paying any money for it, but by making lots of money, usually by advertising. And these sites tend to be, well into the 90% infringing. I'm talking pure infringing, none of this mishmash stuff. It's fully uploaded, ready to go, although every once in a while you'll find a little of that. Notice and take down, notice and stay down, notice and put down is a waste of time against sites like that. It's a joke in our town. Site blocking tends to be nice, though. So what is this exclusive right of communication to the public? And apologies, I'm sure this was covered in depth in the morning. We're talking in particular about Article 3 of the Copyright Directive. I think it's Article 8 of the WCT. And of course, there was an existing rights in the Berne Convention. In fact, the WIPO Copyright Treaty Article 8 is meant to fill the gaps about what wasn't covered in Berne. But what's particularly interesting about Article 3 is the making available right, which is subsumed within Article 3, and for related rights holders also found, of course, in Article 3 too. And that is the right that matters nowadays. That is the interactive on-demand right. That is the right that you sell up front to make movies because you'll get money in from platforms that are offering video on demand, that are offering subscription video on demand, that are offering electronic sell-through. All of that stuff revolves around licensing of the making available right. And that's the right that is infringed by these structurally infringing platforms, and that's why it is so important. That's the right that forms the basis for the carve-out in Article 644 of the Copyright Directive that is so much under attack, that says that you don't have to accommodate an exception when you make content available on demand on agreed contractual terms. That's the provision that prevents a rental of a film from turning into a sale of a film, because that's a different business model. You don't have to accommodate the private copy exception. All of that is contoured around this on-demand right, the making available right. The making available right, a full exclusive right for related rights holders like broadcasters, producers, and performers. Something that the music industry doesn't have for pure communication to the public, they do have for making available. So a crucial right for funding, exploiting, and protecting content in the digital environment. It underpins all new business models and enforcement strategies. That doesn't mean we don't like the reproduction right as well, and it takes on a new gloss with the Filmspieler decision when you think about the extent to which Article 5.1 applies if you're streaming from an illegal source. Hallelujah. But that's just my unbiased point of view. So communication to the public, as we all know, is a kind of endless litany of Spanish hotels, English pubs, Romanian circuses, Italian dentists. I could go on, Czech spas, and on and on and on. And I guess what the latest three cases are a trilogy from the Netherlands, or even more recent is this very interesting VCAST Advocate General opinion. But we start to see, and if you're not a gray-bearded academic, traditional international copyright professor that wrote the guide to the WIPO guide to the Berne Convention, you may still think that this new public thing is ridiculous, but as long as there is a test that has been developed that at least allows you some measure of legal certainty as to whether or not you'll be able to say that a given platform is infringing or that a communication to the public is taking place, et cetera, that you can devise strategies for both licensing and enforcing. So all of that to say that I believe that, of course, that the issue should be a new communication to the public, not a communication to a new public. But the Court of Justice has given us, or looked like they had really given it to us, and then along came AKM, which looks like they've given us a line of case law that we can generally follow and generally understand and think we know what's next, until every once in a while they throw a curveball. And you know, it's amazing, the communication to the public. Was it about a year, 2 years ago? The Belgian ALAI group had an entire day's conference just on the communication to the public right. And you know, when I first saw that they were doing this, I thought, Jesus, what are they going to talk about all day? In fact, it was amazing. It was a really good conference. And it was all capped off at the end of the day with Malinowski basically defending this test and Mihai Fixer storming out of the room at some stage. But of course, there are concerns about the communication to the public right that go beyond new public. Where does it happen? Who does it? And what will its impact be on existing enforcement remedies? That was a concern that was very much at issue in the context of the Pirate Bay case for the reasons that, that you were mentioning, that given the fact that there is no secondary liability at EU level, if the Pirate Bay wasn't infringing, then maybe at EU law they couldn't use someone's services to infringe, and hence maybe you couldn't get an injunction against them. You could fall back on maybe the fact that the end users, the users of the ISP, the access providers, were using the service to infringe because it was a peer-to-peer, so there would be infringements in the end user side because they're uploading, and there are infringements by the Pirate Bay side. But we were going to lose a very important component of the site blocking strategy, and the Dutch court hadn't focused on the end user side. And since there is no concept of secondary liability, as I understand it in Dutch law, there would have been a possibility that an injunction couldn't attach. So the Pirate Bay was an important case. I mean, we had argued for years that the Pirate Bay was making available. We argued it to the Swedish prosecutor in the criminal case, the first case against the Pirate Bay. Granted, that was a criminal case, not a civil case. And he was unwilling to take the risk in a case of first impression, and he wanted to only argue criminal medverking, which is, sorry about my Swedish, which is aiding and abetting. So you do have these funny secondary liability theories that crop up in different member states. None of them I can pronounce. Like there's this thing in Germany called the Steuerhaftung, but it's popular in Los Angeles. You should hear some of the studio lawyers pronounce Steuer. Can we do that Steuerhaftung thing? And so but it's not harmonized, and I would agree. There's very little stomach to harmonize something like that at the EU level. And how would you do it given the different approaches? I mean, the UK approach, or maybe they don't matter that much anymore, of authorization is a very different thing than Steuerhaftung and medverking. I mean, is Steuerhaftung even legal? If it's a form of liability, then how can it be imposed upon you if you are within the safe harbor of Article 14? Maybe it's just a form of injunction. I often wondered about that because Article 8.3 that I was referring to before, that was so much at stake in the Pirate Bay case, is supposed to attach regardless of underlying liability of the platform. So anyways, just to say that, of course, how the right is defined, how the right is interpreted, goes well beyond the questions of where does it happen, who's doing it, what is it, but also the sort of the knock-on effects for enforcement remedies, and for that matter, of course, licensing. So that's the real, we boiled down the test real simple, and it looks like you could apply that to every case until the next case comes along. And I'm still, I mean, has anybody read the Advocate General's opinion in the VCAST case yet? It's a very interesting contortion of also some criticism of the AKM decision. So the VCAST case is about whether or not the private copy exception extends to remote PVRs. But the whole thing begins, well, first he says, well, I think it probably should, but VCAST is getting the content from an illegal source, so it doesn't, and then VCAST is making available. And that's how all of a sudden the communication to the public right becomes important in a case that was extensively about an exception to the reproduction right. He forgets to mention that actually the exception doesn't apply to the, I highly recommend that AG opinion. Hard to imagine how the court is going to follow it, but of course if you've read the AKM decision and you've lined it up again next to the TV catch-up case, you could be suitably perplexed about the other part of the test, the different tech means. And for that matter, if you've wondered about direct injection, you could read SBS and then read Airfield and still be suitably perplexed about how you square those things. So this remains a huge challenge for practitioners wading through this and advising clients about their next step, despite being able to boil it down to a test. So some recent developments, I mentioned the VCAST opinion, I mentioned the Pirate Bay, and of course some of you will be aware of the Geen Steel case. And these line of decision, I think, again, on the basis of new public criteria, which seems strange, seems to be about the court trying to cut the baby in half. From the right holder perspective, this fencing is a serious punch in the stomach that made it look like a right that wasn't supposed to be subject to exhaustion is subject to exhaustion. And then you start to see a little bit of a rollback. If you're linking to infringing content, it's another story. I guess we're going to hear about that later. And again, depending on what kind of a content owner you are, what your business model is, how you distribute your content online, you will be able to live more or less with these different decisions in different ways. And you'll see distinctions between publishers, between music companies, between the audiovisual sector in that regard. So then finally, to talk a little bit about communication to the public issues in proposed DSM copyright legislation. And of course, we have these issues arising with respect to imposition of the country of origin principle on the rights that are implicated by certain ancillary online services of broadcasters. And the idea there is to basically take the first pillar of the SAT-CAB directive that, looking around the room, I know there's a few people in here that know that one very well, and imposing it to broadcasters' online ancillary services, but with respect to communication to the public, making available, and reproduction rights to the extent that they're implicated by the given service, which would be the case, for example, with the catch-up service. It's causing a lot of confusion because I'm not sure who is a broadcaster anymore. Because most broadcasters, if you think about SBS, don't appear to be broadcasting anymore. They are like content aggregators. So for the purposes of the first pillar of this broadcasters regulation, when the legal fiction, when the country of origin principle bites, when does it bite? Does it bite when is it actually the platform? Does it bite when the platform makes the service available? Or does it bite when the broadcaster that licensed the platform? Or does it bite when the producer licenses the broadcaster? So there's some confusion there, and the commission specifically or expressly decided not to define broadcaster, and it's not really defined at EU law what a broadcasting organization is. I guess on the theory that you'll know one when you see one. Communication to the public is affected by the provisions in the second pillar on retransmission, and of course the issue of direct injection, which is a very interesting case that this decision was rendered before the proposal came out, the SBS Belgium case, that basically says that broadcasters that direct inject are not communicating to the public because they're just sending their signal to the platforms which communicate to the public. That case is a major, major change for the entire paradigm. You have authors and producers that receive a lot of money from collecting societies for retransmission, but well, what if the platforms aren't retransmitting? Yet we have a proposal that a whole new raft of retransmission services, satellite, DTT, IPTV, mobile, and of course the Parliament is suggesting open internet, would all be subject to the second pillar for retransmission, i.e. mandatory collective exercise of rights with a broadcaster veto. But what's actually going to be in there if if all of the broadcasters in Europe, and it's like 80-something% now, are delivering their channels by direct injection, and according to SBS, not communicating to the public. So of course there's going to be a huge fight in the contest of the broadcasters regulation. There are a number of amendments that have been put forward in Parliament to bridge the direct injection value gap. We've got lots of value gaps in copyright. And we'll have to see how that goes. There, you know, some of those proposals look back at the Airfield decision and the concept of a single act of communication to the public for which the broadcaster and the platform are jointly liable. And then there are other ideas around another legal fiction that says that a direct injection would trigger the mechanism for collective management of rights. So we'll have to see. So far, nothing at the member state level. And I understand at the Legal Affairs Committee hearing the other day, the Commission was still saying that they didn't think that a change was necessary. And then, of course, in the other big piece of legislation, copyright in the DSM, or the proposed copyright in the DSM directive, there is another provision that, depending on who you speak to, would implicate the communication to the public right. And it's an amazingly interesting debate. And again, you know, it depends on where you're sitting about how you interpret things. The lead up to that proposal, tell me if I'm getting too much on time.
No, yes,
The lead up to that proposal saw, in particular, an amazing initiative by the music sector, the producers and the authors, in particular, to explain and sensitize people to this value gap issue. It was referred to before, basically, you know, transfer of value from rights holders to YouTube, basically. And that was an amazing success in the sense that they got people to buy into that there was a problem. Well, that's always the first step, getting people to buy into the fact that there's a problem. And, you know, it was kind of nice that for once, you know, the music industry was saying, you know, this is a licensing issue and not an enforcement issue. And they had gotten on with licensing these UGC platforms, providing these blanket licenses, which meant that all activity on these sites was basically authorized, either because of the authorization or because then maybe in the rare instance an exception might apply. They got on with it and they started, you know, securing revenues from some of these sites. But of course they had this issue that it was relatively derisory and they could always fall back on the safe harbor. So they got, let's say, buy-in to the problem. Well, once you get buy-in to the problem, then you need buy-in on the solution, and that can be even harder. What is the solution if the real problem resides in Article 14 of the e-commerce directive, and we're not going to touch that? Or the real problem resides in, we should make it clear what the scope of Article 3 of the copyright directive really covers. And, well, there's a whole bunch of other rights holders, audiovisual industry in particular. Ooh, don't touch that right. It's sacred. Be careful. Don't touch it. And then, of course, you've got, you know, a whole range of stakeholders that are saying, you know, Article 15, e-commerce directive, you know, the music industry, this has gone too far, free speech. So you get this solution from the Commission that I call it threading the needle. That is an incredible attempt to try to walk an incredibly fine line that at least tries to satisfy everyone. Obviously, it fails to satisfy everyone. But you could also say if everyone's pissed off, the legislator always thinks they've done a great job. And that Recital 38 and Article 13 read together are pretty much, you know, tottering on this high wire. And again, there are criticisms that can be made about it. Does Recital 38 actually say that these sites that store and give access to large quantities of content are communicating to the public, or does it just suggest that they do? I've heard lots of different debates. And the Court of Justice has in any event said it's a case-by-case determination. That the language is pretty strong in 38, thereby. So I tend to lean towards it says they communicate to the public, but it's only in a recital. And it doesn't say that in Article 3. So it also says that the e-commerce directive is unaffected. They didn't originally include a reference to the e-commerce directive in Article 1, which you would normally have expected to see. Why didn't they do that? Probably I would have done it. I would have said, yeah, of course it doesn't affect the e-commerce directive. And you know, when in the middle part of recital 38, well, all that really is just a nice, faithful codification of existing Court of Justice opinions interpreting, decisions interpreting Article 14 of the e-commerce directive in any event. Another thing that's very interesting about this, I mean, the filtering points, all of that, I mean, I tend to think of Article 13 as a specific emanation, and you suggested this a little bit, a kind of specific emanation of an injunction that you might be able to get under Article 8.3 from, you know, Mr. Justice Arnold, or, you know, someone that really understands copyright law. But you have to look at it in two different ways, licensing versus enforcement. Some rights holders look at Article 13 only through the eyes of enforcement because their business model is not licensing platforms that way. And if you look at it from an enforcement point of view, having an extra tool to go against structurally infringing sites that will play ball, which are very few, and that you can actually find, well, it would be nice, but will it make much of a difference? So a lot of concern there also about getting this right so it doesn't upset the apple cart. My sense is that the other shoe hasn't dropped yet on this provision. We haven't seen too much radical stuff. There's a fair amount of crap in Parliament, but you'd expect that in terms of the amendments, in terms of making the whole thing much more onerous. If you adopt a UGC exception, well, the whole thing becomes nearly pointless. You know, we'll have to see how it goes. But in Parliament, I mean, in the Council, it's the very beginning. And I'm hearing that, you know, people want to rewrite the whole thing. And what about the Googles of the world? And when they, you know, is there going to be a SOPA PIPA moment for this? So we'll see. It's incredibly interesting, but we're still very much, I think, in the middle of it. So that's a bit of a perspective, mostly from the audiovisual sector. I have to wish you all peace, love, and copyright, and thank the ECTA folks for having me on the panel.
Thank you, I have my usual question, and the question, there are many, but since I've already been accused of being bombastic, I will keep to the subject matter.
That's all right. I'm happy for you to be bombastic. You can, you know, you can hang yourself.
So what do you think that this proposed legislation and regulation, directive, will have on the future of the community to the public right as interpreted by the Court of Justice? So what do you think? Even because Juliana is going to go there too. And I would like to understand, because I noticed that you quoted, for instance, the Playboy case, which, without any kind of shamefulness, I can say that when I was at the IPPI Baltic conference, I strongly criticize as being one of the most dangerous provision in terms of consumers' rights, right to privacy, right of being able to do your things without having a presumption of guiltiness. We were talking about this. I mean, for the first time, we found that there was this kind of things that was very, very good in totalitarian state, which was that you are guilty unless you're proven innocent, which was the first things that the totalitarian state can do, and I think that we will agree on that. Not for things that you do is you're guilty and you have to prove your innocence. And normally democracy, and I think that the Magna Carta and the Bill of Rights in the United States, it's started exactly on the other side, that you are innocent until proven guilty. And in that case, to me, it's very, very, very alarming for the compression of rights. So what do you think that this is communication to the public is going to go?
I'm not sure I understood the question. Can you rephrase it?
Okay, so you were talking that this communication to the public has been extremely important and sometimes being confused with the right licensing and so my question is, what do you think that the Court of Justice is going to go with this? What do you think that this concept is heading to? Can you make a reasonable assumption on the communication to the public? I mean, what is it going to go? Is it going to be
okay? Well, I guess
going to be.
I referred to it a little bit. I tend to think of the Court of Justice, whose decisions are sometimes indeed difficult to swallow, as a very results-oriented body. It's kind of like they look at a particular fact pattern that is in front of them, and they decide what they think the outcome ought to be, and then they reverse engineer it. And we've seen that. I mean, you think that the GS Media decision is a threat to democracy, and will restore Mussolini's 1941 Copyright Act for Italy, which, by the way, I think is still in force. 42, sorry.
Yes, it is. Yes.
But in fact, we also had poor Miss Britt's privacy was, before she was about to expose herself completely in Playboy, her privacy was compromised by the anonymous leaker. But I detected in GS Media, and I've seen this, I think, to a certain extent in the Pirate Bay case, that they have that they try to come up with a justification for the end result, and they try to balance it. And in doing so, they create some funny law sometimes. The new public thing, this presumption, if you're making money, there's a presumption that you know, and that is some kind of weird concept that, I mean, first of all, it's copyright infringement is strict liability. You don't have to prove knowledge there. So it is a bit weird, but they think that they've done something for innocent linkers, that who won't be caught by that presumption of knowledge and therefore won't be communicating to the public. So they think that they've cut the baby in half. They think that they cut the baby in half with Svensson and with all the way down the line, that they have provided a measure of protection for rights holders, but try to balance that against competing fundamental rights. We can quibble about whether they've got the balance right in each one of those cases, but that seems to be their goal, and it's consistent normally. I mean, every once in a while when you think you've figured it out, you get, as you said, these decisions like TV Ketchup said that if you communicate to the public by means of another technology, you don't need a new public. And then they appear to completely jettison that in the AKM case. So, and then you're kind of like, well, how do we distinguish them? And apparently, lawyers are not allowed to distinguish things just by saying, well, the court was really stupid that day. So you've got to come up with better means to distinguish. And in fact, it's interesting how the Advocate General sort of invites, and they do this, the Advocate General, sometimes in cases, they invite the court to, think about it one more time in this particular. But as a general answer to your question, I see the court as trying to maintain a high level of protection while not overly impinging, while balancing correctly the competing fundamental rights that can be at play. And it's always better to have a good set of facts. Saddam should be banned from ever taking any cases to court, okay? There should be a rule that says Saddam is not allowed to go to court. I've told them this before, and I'll say it again, they have made so much bad law through bad choices. When I was at the Motion Picture Association, our credo was sue really bad guys and make sure the judge knows they're bad. Because that's how, coming back to the results-oriented thing. The Court of Justice was looking at the Pirate Bay. They were looking at these egregious infringers. They weren't looking at Netlog, a social media site, a successful European social media site. I mean, come on. And I mean, the injunction granted in the Sabam case, which wasn't as broad as the way that the Court of Appeal referred to it. I mean, basically, the Court of Appeal of Brussels asked the Court of Justice, can an ISP be ordered to stop piracy in our time? What did they think the Court of Justice was going to say? So anyways.
So what the impact of this legislation will have, now that you're talking about the court, and so what is the impact of legislation on the other hand?
Actually, I thought your predictions about what the Court of Justice might make of a future Article 13 were very interesting. And I think applying I think it's consistent with what you were saying, that they will look at this, again, who knows what it's going to look like when it finally comes out the other end of the legislative meat grinder. But let's just say for the sake of argument, that it looks more or less like what the Commission said it should look like. The Court of Justice will have to bring some more certainty to it, and they may well do what you said. They will try to constrain it so that it doesn't overly impinge on competing rights. They may, or they may continue to obfuscate. But my guess is that they might do what you said about try to limit it to similar infringements. I think you're probably right. If it's the second option, then it's pointless, at least from the rights holder perspective. And so it really has to be the first one.
Well, it's very interesting because our last speaker, which was supposed to be the second to the last time, Leon, is going to have a very interesting subject, which is going to a little bit overlap, but it's going to move, and it's the hyperlinks and communication according to the Court of Justice case law. So a little bit about Leon. Leon is an alumni, so I feel that I'm particularly close to him because he's a 2013 Bolt-Hall LLM. It was 1993. Oh my God, 20 years already. Mm-hmm. And so we have a kinship which takes us against those who are in Stanford. Go Bears, go Bears. And Leon is an associate with the Office of Owing, Rock, and Monegear. I hope I said it well. He advises litigators in cross-border patent case and trademark in an area of technology. As co-authored, it's another author, so we have here another author. So you see, they're all guys that have a stake in copyright, a personal one. An annual digest in Dutch patent law cases. He's representing a client in front of the UE IPO, the new EU office, and General Court. Is a member of ACTA, so it's... And we recommend everyone who is not member of ACTA to try to think of joining ACTA so that you can have not only access to this beautiful workshop, but also to our great conferences where we have a lot of very talented speakers and very interested sessions before and after. So if you want, then there is Anna, and you can ask her information how to become member of ACTA. Sorry about this. Bing. This was promotion. It was also, I didn't know that you were also an extant to George Alsup. I think I've known him. It's someone pretty important down in California. Huh? Yeah. And he won the Amsterdam Young Bar Association annual pleading contest and finished third in a national competition. So, Leo, the floor is yours.
Well, Fabio, thank you very much for this, this very kind introduction. There is one thing I should add to my resume, and that is that I really enjoy watching cat movies online. This being one of my favorite subjects. He's pretty well known. He's called the Grumpy Cat Tartar Sauce. That's his real name, at least, but everybody knows him as the Grumpy Cat. I actually heard this morning that 20% of the internet is cat movies. So it is really quite a popular pastime that we have here. Even almost the presidential-elect was enjoying them. Now perhaps even more so. But seriously, the Grumpy Cat, he's become really famous. He's got a Facebook page. And this was a screenshot that I took of just a random picture that he uploaded. And you see here, it was shared over 1,000 times. And this is just one random photo of the Grumpy Cat that was shared on one random day. So you can kind of see where I want to go here. This is like a big thing. This is the architecture of the internet, people sharing things, putting photos online, showing it to others. And the subject of this presentation really is how do we go about that. Here you can see the very impressive following that the Grumpy Cat has on Twitter. Here we have some variations on Grumpy Cat pictures on Tumblr. So the point is, you get the point, there is a lot of sharing of this content going around, and the question is, how do we deal about that with copyright? So you might imagine that rights holders may be, well, grumpy when they realize that their content is being spread all over the internet. And just for the sake of clarity, I just wanted to name a couple of things that I'm not going to be talking about today. I'm not going to be talking about memes, that is adapting a picture and making a new work out of it. I'm also not going to be talking about printing the work on t-shirts and then commercializing it in this manner. And I'm also not going to be talking about retransmitting the work in some other form, in this case, Grumpy Cat, the Christmas movie. No, so this is just going to be about hyperlinking on the internet and how that is dealt with by the Court of Justice in the European Union. And I'm not sure how familiar you guys are with the case law of the Court of Justice, GS Media, Svensson, these names have been dropped. I thought I would just go through them really quick so that everybody is sort of on the same page here, even those people who are not intimately acquainted with copyright. But I'll try to be as concise as I can so we can move forward to the discussion. So the basics bring us right back to Article 3. Ted was already talking about it. And within this Article 3, it states, member states shall provide authors with the exclusive right to authorize or prohibit any communication to the public of their work. So the two most important aspects of this provision for our purposes are, one, communication, and two, to the public. And so there's much to say about what is a communication. The Pirate Bay case is a prime example of something that I wouldn't necessarily have thought 2-3 years ago would have constituted a communication, but it is a communication now. Filmspeler, another example. Right now, the most important thing to keep in mind is that a hyperlink is a communication, which I think is fairly obvious. I mean, I guess you could think differently about it, but I think that's very reasonable to say that. And there's also much to say about to the public, which is what I'm going to be focusing on for the rest of this presentation. So there is a lot of criticism about the way that the Court of Justice interpreted this, and the trouble really all started with the Hotellus case, where, as you know, this was about broadcasts on television, and let's say that we have an item on our Grumpy Cat there, and a home viewer of the item. So if he sits at home and he watches the television, there's not a problem. There's the broadcast is directed to him as the television owner. He watches it in his own private home. No problem there whatsoever. But what if the home is a hotel? What if each hotel room has television sets with people watching this same broadcast? What if, in other words, the hotel owner splits up the broadcast and divides it over the rooms? Well, says the Court of Justice, in that case, the clientele of the hotel forms a new public, because the transmission of the broadcast work to that clientele using television sets is not just a technical means to ensure or improve reception. It's not like you're amplifying an existing signal or anything. On the contrary, the hotel is the organization which intervenes in full knowledge of the consequences of its action to give access to the protected work to its consumers. And in the absence of that intervention, its customers, although physically within that area, would not in principle be able to enjoy the broadcast work. And here I think we really see the framework being built for the later cases that sort of explain how to deal with this hyperlinking in the internet context. And really, I don't think you can understand cases like Svensson, like GS Media especially, without looking first back at the Hoteles case. But then a couple of years later, the question is asked, of course, how does this work on the internet? We get Svensson, and in Svensson, as you know, it was about a newspaper publication. Just by way of example, I've selected this one to keep it in line with my hobby of the cat movies. And of course, somebody posted a link to the newspaper paper article, and the question was then, okay, how about this, Court of Justice? Is this a communication to the public, and how should we see this? And so the Court of Justice then, in paragraph 26 says, and this is probably the most fundamental aspect, I think, of linking on the internet, the public targeted by the initial communication consisted of all potential visitors to the site concerned, since given that access to the works on the site was not subject to any restrictive measures, all internet users could therefore have free access to them. I thought I'd let that one sink in. All internet users, that means essentially everybody with an internet connection, essentially everybody. And so here we have this legal fiction, right? Because it is clear that, realistically speaking, a Swedish website, a Swedish newspaper, which the case was about, is not targeted at everybody, if only because it was in Swedish. So it is clear that realistically, this is not how it works. But we have this fiction now that says, if you have content online, it is directed towards everybody. And so then the Court of Justice goes on, and it says, well, in those circumstances, if you provide a link to other people to this content, then that's, you know, the content was already directed at them. If you transpose this back to the Hoteles case, you would say, okay, 100 people, like let's say 100 hotel guests, they can't all look at the same television set, but they are all, you know, targeted by this internet link because they can all access it on their phone. And if somebody links content to another hotel guest, they can say, hey, yeah, well, that's great, thank you for pointing it out, but I was already a recipient of this information. And so this is this fiction that you have to keep in mind always in these internet linking cases. And therefore, concludes the Court of Justice, since there is no new public, the authorization of the copyright holders is not required for a communication to the public, such as that in the main proceedings. And so then everybody thought like, okay, wow, this is, well, maybe not great, but at least we have some clarity now on this issue. But of course, the big million-dollar question was, what about unlawful content? People thought that maybe there were some hints about this in Bestwater, but then the court didn't really address it, unfortunately. And then it came to GS Media to settle this issue once and for all. Well, as you know, it was about Playboy Pictures. Ted already mentioned it. The real ones were perhaps a little bit more enticing. And then
she's naked.
Yeah, it's true. It's true. And this is the Geen Stijl item that was written about it. And so you can already see kind of, at least the people who speak Dutch, it's very sensationalistic, you know, it says fucking leak, pardon my French. So they know very well that this is illegitimate content that is being linked here, but yet they place the link towards it. And so what does the court do with this? Here's the relevant provision. It says, okay, well, Svensson and Bestwater, that's what I mean by those decisions, they really intended only to the situation where content has been placed online with the consent of the rights holder. To the contrary, in a situation where you do not have consent, the court says, where it is established that the person knows or should have known that the content was placed without consent, he will essentially make the work available to the public within the meaning of Article 3.1 of the directive. So essentially, the court is saying it is all about the subjective state of mind of the content holder, which places this content online. We are then supposed to deduce this from objective criteria, and the linker is supposed to know, and then GS Media, of course, gives us some information about how they can know. For instance, if there's a notification, for instance, if you have to circumvent technical measures, and these are things that I'm sure will be brought up in subsequent litigation. That was my very brief summary of where we are now. So just to summarize it, we require, for the purposes of this presentation, an active communication targeted at a new public. And where it is uploaded with the consent of the right holder, it is directed at everyone. And where it is uploaded without the consent of the right holder, it may provide a link to a new public subject to certain conditions. And I was interested by what Ted was just saying, how he feels that the Court of Justice is really having this result-oriented approach towards these kinds of problems, and I wholeheartedly agree. That really seeps through in all these decisions. When you read them, you feel like, okay, they really want to strike a right balance here, they want to be pragmatic. And the question then is, did they succeed in doing so? I will leave my personal opinion on this to the end, but first I will point out that not everyone is happy. And one particular set of criticism from mainly academic circles is that, well, this criterion that they came up with is not in conformity with the Berne Convention. There was some considerable debate about this in academia, and I thought I would just sort of address this because I think it is a nice background to arguing the merits of the approach that is currently taken. So let's go back to Hotellus, because that's the basis. Here, the Court of Justice in paragraph 4, they actually said they are applying a rule that is in conformity with Article 11 bis 1 subset 2 of the Berne Convention. So they're saying, okay, we've looked at this and we're applying this, or at least we're applying the directive which is in conformity with the Berne Convention. And in the first sentence they say, oh yeah, this article of the Berne Convention, it requires a new broadcasting organization. And then all of a sudden they come up with this new public criterion saying a new organization, that means, thus, a transmission is made to a public different from the public at which the original act of communication is directed. That is a new public. And so these academics, these critics, they would say, hey, well, that's not what I read in the Berne Convention, because the Berne Convention and the specific provision that they're referring to, it doesn't say anything about a new public. Nothing. They just say a new organization. However, I personally think that these criticisms are not entirely convincing. I mean, what they say essentially, to my understanding, but I wonder if somebody here in the audience is actually predisposed to this criticism, in which case I think we can have an interesting debate about this. But to my understanding, they argue that, okay, this is a violation of international norms, namely the Berne Convention, and it leads to erosion of the rights holder, because the rights holder was afforded stronger rights in the Berne Convention, which are now effectively being eroded in a system that is very much like exhaustion in a context where exhaustion shouldn't occur. Well, as indicated, I don't think it's particularly convincing because, first of all, in my reading of Hotellus, this new public criterion really follows from the facts of that case. Because think back about the hotelier looking at the television set in his own room. Then clearly there would be no communication to a new public, there would be no broadcasting organization. And then these critics, they say, well, Hotellus would have been decided the same way because the hotelier must be considered a new organization for the purposes of Article 11. But then the thing that makes him a new broadcasting organization under the facts of that phase is the new public. It's the hotel guests. There's no other way around it because he's free to look at the hotel set himself, but he is not free to make adaptations so that other people can watch it that were not intended with the original broadcast. That at least is how I read the case and how I think you can read this new public criterion into the Berne Convention. Then my point of view is that the new organization criterion, which the proponents say is so much clearer than new public, I think new organization is very hard to apply. To just name one example, the most important one I think for the Court of Justice, what about individual internet users? Can they be an organization? If I post a link online, am I an organization performing a new broadcast? If you know, if no, then where do you draw the line? I mean, what if I, you know, make a lot of money from this from the site that I'm running, even though I'm an individual? What if I link to clearly infringing content? That, you know, making an individual not an organization would really place them outside the scope of copyright infringement, which I don't think is desirable. But then again, the other alternative is even worse. If you say an individual can be an organization within the sense of the Berne Convention, then when are you ever free to place a hyperlink on the internet? And I think that is precisely the type of issue that the Court of Justice was seeing and that they wanted to avoid, and that's why they sort of twisted it to this new public criterion. And in any event, to borrow Fabio's beautiful phrase, the cattle has already left the barn. I think the Court of Justice has been invited numerous times to come back to its new public criterion. Lastly, of course, by the Advocate General in the GS Media case. They have not been willing to do it. They're not going to do it, I don't think. And the question is then, you know, what can be done? There is no higher authority that can sort of force them to comply with the Berne Convention. And in that sense, the Berne Convention is kind of like a paradoxical instrument, because on the one hand, it gives us this worldwide harmonization of copyright, which everybody uses, you know, to sort of claim their cross-border injunctions, where you see these trends where national courts are saying, well, I can impose a worldwide copyright injunction because, you know, it's just harmonized to a large extent. At least Dutch courts are willing to do this in the European context, but we've seen the Canadian court willing to do this worldwide with Google. And I think, you know, the basis for this is having some basic harmonization in the form of that Berne Convention. So you have that tool, but on the other hand, there is no uniform interpretation of the Berne Convention in the sense that there's no uniform authority able to give guidance on this. And this, I think, creates, you know, an interesting paradoxical situation, but yeah, that's just, I guess, the way things are and the copyright acquis that we are having to deal with as practitioners.
Certain aspects of Berne are covered by TRIPS and therefore subject to WTO. I mean, it's far-fetched, but could happen.
Yeah, but you mean the panel?
No.
Yeah, but how would you see the panel intervening in the European legal order? We had this.
We had this discussion before.
It would have to be another member state of the WTO that brings the EU to Geneva for failure to meet its international obligations. It's unlikely to be the Americans, since they lost the last case and still haven't fixed their house. But that is how it would have to play.
Yeah. But we had this discussion exactly before when we were thinking of this. And one of the questions that we had was, do you ever envision the United States being brought in front of Geneva because of a decision by the Supreme Court and have a Geneva panel say to the Supreme Court that it has to revise its case law or its jurisprudence because it's against the WTO? But would you expect the Supreme Court to take orders by?
Well, I mean,
honestly, from a constitutional point of view, we have serious doubt that the WTO would have jurisdiction.
The U.S. Congress, which is an equally lofty American institution as the Supreme Court, has been told exactly the same thing by the panel. They have been told that the unfairness in music licensing statute violates international norms, and they should change it. They have said,
okay, but that's another thing. But
that's because international law is something that Americans expect from others.
But because here the problem is that we are discussing. Let's finish so we can go there because I have a question and then we'll
I'm sorry.
No. This is great, and this is what I was hoping to achieve also with the presentation. And my personal view is, I think the European government, or I guess the Commission, would have the same response. I mean, they have other things on their plate to deal with than like abiding by the WTO, and I don't think...
They have a much better track record. The EU has a much better track record in abiding by its international obligations, at least in the copyright. Then, I mean, look, the Americans are still in breach of that decision, and it's unfortunate because the three-step test, it would be a great tool to run around and bang people over the head with.
Yeah.
But they're in a kind of compromised position because of that.
Yeah. Well... you know, of course, it's anybody's guess what actually would happen in this situation. But I think in any...
Well, that's another matter, isn't it?
Yeah, that's true. Yeah, and in any event, I think we can all agree that the new public criterion, and that was really my point, it's not going to be abolished anytime soon. So I guess we'll just have to start dealing with it, even if we're not entirely happy with it. But having said that, I am quite happy with it as a practitioner, because actually also precisely for the reasons that Ted was saying. Okay, so it requires some mental gymnastics. So where we have the situation, we have this fiction that all internet content is directed at everybody, subject to the subjective state of the rights holder, which is deduced by objective criteria. I mean, here there are so many fictions flying around, it's hard to keep track. But precisely what Ted said, we at least have some kind of framework to deal with. We have something that, you know, it's not perfect, and it's certainly far from done yet, but it is something that will allow us some kind of, you know, certainty going forward in the future. And I think if you look at, you know, the Court of Justice's cases in the trademark area, you really see them being hesitant about allowing trademark owners to claim large pieces of, you know, the public domain or trade dress or things like this, because they really want to keep things open for the public to use. And on the other hand, they're worried about rights holders, not, you know, their rights being eroded. And I think in the system that we have now, which very broadly speaking comes down to, if you are a rights holder and you don't like, you know, your content being online, keep it offline, and then when it appears, you start notifying everybody as soon as you can and hope for the best. I mean, you know, there are practical consequences that, and considerations that may make it difficult, but at least, you know, at least it's something. And I have personally not heard yet a system that would be much more easy and much more easy to apply and clearer, and yet still strike the same balance. But of course, I'm very, very happy to hear it if somebody here has ideas about this. And there are two things that I would like to say about this. The first one is that we shouldn't forget that this also has very important consequences for models of revenue generation on the internet, which is why I included this little picture here. You know, some people may be happy about this, especially people proponents of the free internet, but we mustn't forget that the major model of revenue generation on the internet nowadays is free content funded by advertising. And according to, you know, if you follow the Court of Justice's approach, then that means that you can essentially embed all this content on your own site and put advertisements around that and piggyback essentially on the content of this other site. And there has been in the Netherlands, where I practice, there has been a case where, you know, you had these radio stations that, of course, advertise on their site when they broadcast internet radio. There was this aggregator aggregating all these radio stations from the Netherlands and making money off of revenues. This was a case that happened, I think, in the early 2000s. And then the court said, well, you know, that's unfair competition because you are clearly using these radio streams of the different site and then making your own buck off of it with your own revenue income. But since Bestwater, we know that this is perfectly legal because the content was placed online with the consent of the right holder, and there's nothing you can do about it. So the site is back online. It's very useful, actually, if you like to listen to the radio. And that's, I think, precisely what the Court of Justice wanted to do. You can't make an omelet without breaking some eggs, and this is unfortunately something that had to go. And then the second thing that I wanted to notice is, again, what Ted already mentioned, the curveball aspect of EU copyright law. I think if we have this seminar again in 2 years, things will be looking much different then. So it's always an interesting thing to keep the latest developments in mind. So, yeah, if there are any questions, I would be happy to take them.
And I have the question for you. And the question is, we go back what we were discussing before, so we re-engage in the discussion which before I stopped, but only because I wanted to let you finish. And it says, so this new public criterion is not in the Berne Convention. Do we agree? Even if it's called organization, but it's an organization, cannot be any public. So I mean, the word have a meaning. So it's not in the Berne Convention. Is not in the directive. There is nothing in the directive talking about this. And yet is a criterion that is now being applied. Now, is this judicial activism, you want to call it in this way, to use a term that is dear to the Americans? Is this something that the ECJ had in its in its basket of weapons of mass destructions, with all due respect for my bombastic reference to weapons, was something that you think, to go back to what we were talking about the WTO and what we were discussing, so that as long as this is jurisprudence, I see very, 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 very difficult that the WTO may impose to a court or to the member states to overrule a court. Even if we don't have the same decision by the Supreme Court and by the decision made versus Madbury, that it is the realm of the court to say what the law is. So it's not the Congress, but it's what the Supreme Court is. And the same is for the CJEU. I mean, I do not see. So do you think that the only way would be that maybe that would mean a legislation that translate this new public into some kind? If it was taken, then you could have maybe a WTO decision that would say that the law that has been implemented by the Congress or by the Parliament is against the WTO, international law, and blah blah blah. So what do you think? There's a lot of things to say. Yeah.
Yeah. I'll just focus on the judicial activism point because I think it is interesting. But I think if you have a constitutional order such as the European Union and you have legislative instruments such as directives, then you necessarily need an activist court to fill in the gaps. Because otherwise, it's very hard to build an acquis in this way. But to answer your question, yeah, I think that it would be good if a new public criterion would be put into law, with the new copyright legislation, to give it some, democratic legitimacy. Because it's true, it just came out of the high hat of the Court of Justice. But I think that's what we wanted to do. It is by nature a very activistic court.
What do you think, Dad? Would you like to have a new communication? I mean, a new public?
No, I like new communication better than new public. Yeah. No, I think you have to draw the line. I agree to a certain extent that we need the Court of Justice to have a harmonizing influence. And there will necessarily be in the bare bones of a directive sometimes gaps that need to be filled. The question is, how far do they go when they start making law? I don't know that new public is making law. It's on the borders. I don't know that you're right. I agree with most of your presentation. I don't know if you're right in saying that new public really is just the same thing as new communication or new organization.
Well, that's on the facts of Hotelis.
I can see how that works in some cases, but might not work.
Yeah.
In others where you could easily assimilate the two and you may not be able to assimilate the others.
Yeah.
But I do agree with the core core points, and I think I said it similarly, that ultimately we need tests that we can apply.
Yeah. And
we need at least some legal certainty. And the court is continually trying to cut the baby in half. Under a concept of international law is that a country that has agreed to be bound by certain international norms may not invoke national decisions as an excuse for lack of compliance with those obligations. The corollary to that is that it doesn't matter if the Supreme Court has said X, U.S. can still not, or whatever country it is, can still not say, oh, sorry, Mr. WTO, or whoever it is, we'd love to comply with your stupid ruling, but we can't because we have this domestic problem. It does get very difficult, though. So you can overrule the Supreme Court, or you can overrule the Court of Justice if you're amending secondary law.
Yes. Yeah.
But if you're amending the treaty, well, they are the sole arbiter of the treaty, of interpretation of the treaty, just like the Supreme Court would be the sole interpreter of the U.S. Constitution. Then your question gets much harder. Because are we then saying the WTO gets to amend the U.S. Constitution? Yeah. Does it get to amend the treaties? So then it gets harder. I'm very doubtful that the U.S. is ever going to bring this case, given the way that the political makeup is, and for that matter, the existing state of U.S. law. Do you think the making available right goes this far in U.S.? Do you think any of this stuff is communication to the public? They won't even have the making available right. So
yeah.
At least specifically, we have combination of distribution and public performance.
So, yeah, go.
Microphone or without microphone?
So, Does it work? Okay. So yeah, I mean, I think that last remark is actually, I think the whole exercise of whether this is compliant or not, just because we have something in the law that it's not on the international level is not important, because the real question is, are we providing less rights that the Berne Convention prescribes? And as you answered yourself, the US certainly doesn't go that far, and I think Europe definitely goes as far as you can get so far with this right. So I think we certainly are not the country or the region to be blamed for underprotecting. So it's very unlikely to see any complaint before the WTO against a country that has probably the broadest, online exploitation right. Yeah. I have a question for you, Ted, before you leave. Since you see Article 3 as such an important right, and of course it's becoming the crown jewel as the reproduction right used to be. My question is, how do you see this, because something I couldn't understand. In the presidency proposal, they have this new proposal for saying that if there is an agreement, regardless of whether it's the agreement, monetization agreement or licensing agreement on the right to communication to the public, then if there is some licensing, then that also covers liability of non-professional users, something like that. It's very difficult to reproduce. What is that meant to do? I have such a big difficulty to understand what this is meant to do, and I really like someone from the industry to explain what is the purpose.
Well, I don't understand it either. I saw that and thought this is outrageous.
Okay.
I guess what they're trying to say is they want to make sure that the users are covered. But I don't think it needs. If you clear the rights, they're cleared.
Yeah, that's my point. I mean, so what about professional users who are not covered, whatever that means?
Frankly, I saw that and thought it was
so that means
Estonian
that
overkill.
Platform licenses, but professional users have to license in addition, because the platform cannot absorb licensing for the users.
I guess they're trying to make that distinction, but I don't know why they're bothering. Yeah, I saw that and thought that this is silly.
So for audiovisual, this doesn't make sense. It might be probably for music, maybe?
I could have asked Christina, but she's snuck out. I don't think that the music industry is interested in that either. But I don't know that. I don't know that for sure. I think that they see that as protective of users. There are a few similar things. I think I've seen a few similar things in some of the amendments in certain committee. But I saw that as them trying to be protective of users, to make sure that they were exonerated. All right. Well, thanks, everyone. I've got to run.
Thanks.
Yep.
Thanks,
Thank
Ed.
you. Say hi to Joris.
Any other question? Any other? And not only to Leon, but also to Felix and Sebastian, I mean to the earlier speakers. If there is any other?
Just one question for Leon. Regarding the idea of trying to carve out the jurisprudence of the ECG regarding the hyperlink through unfair competition. We refer to a case of the early 2000s regarding the fact that when you take over something that is maybe copyright or not copyright protected, could also be an act of unfair competition. Couldn't that be an idea for right holders just to say, hey, you can't just do hyperlinking without paying me or something like that? Because that remains something that is completely out of the scope of the IP protection, but still can be.
Yeah, I get what you're saying. Yeah, so I think this may also be a peculiarity of Dutch law, because in Dutch law, in order to get to unfair competition, there needs to be some kind of norm violation at some point. So you need to have, I mean, essentially unfair competition. And in the pre-Bestwater case, people were thinking, okay, well, surely there must be some kind of like copyright infringement here, or at least something that approaches it, because you are really just free riding on the efforts of these radio stations. But now, yeah, and that's still the case. But now you don't have a copyright infringement anyway, anywhere. The only thing that you have is this free riding aspect, but you're free riding by doing something that's completely legal according to the Court of Justice. And at least under Dutch law, there can be no unfair competition claim then, because the only thing you're doing is linking in a legitimate manner. which I'm, but I would say that maybe this is something that could be subject to a different national law, that this could be an unfair competition claim. But at least in the Netherlands, this is just one example that I know of, where this literally changed back after a negative ruling that was handed down in first instance, after Bestwater was decided.
Because when you see, for instance, in France, when you have a counterfeiting case, what you usually do is you always try to have a claim based on IP infringement, and you always do it as well as it's unfair. If it's not an IP infringement, in any case, it's unfair competition, and in many cases, you see, the court saying, indeed, there is no IP protection, or it's not an infringement, but still, it is unfair competition because of free riding.
But don't you need, I mean, just at least the Dutch Supreme Court has always time and again emphasized free riding is great. I mean, great, but yeah, they say, the free market, that's the basic principle. And if you can use somebody else's efforts to your own advantage, better for you. So there need to be additional circumstances in order to make that unfair competition.
Because there are some Central European countries. There are some Central European countries that exactly have this sort of debate with respect to linking. So to what extent unfair competition law can provide some recourse on top. And I think one of the things that, of course, it's completely non-harmonized area. Protection against misappropriation beyond unfair competition law is unharmonized if there are some IP rights. But one of the things that is often forgotten, and I think really it's like someone should spend more time writing about this probably, is really the fact that the secondary law and also primary law have impact on unfair competition law through IP law, because the fact that we have tightened the screws through communication to the public and then said that embedding is fine from the perspective of the copyright, and actually we have said that it's a maximal harmonization in Svensson, that's the second response to the Swedish court, that actually preempts, in my view, in my reading, by secondary legislation that the domestic unfair competition law enters that domain by claiming, oh, but it's illegal under some other doctrine. So that's at least in hyperlinking scenario. Of course, in other scenarios, there might be no exhaustive claim from the secondary law, in which case I think you still should think about the primary law and free movement of goods and services, But, I personally think that there is a lot to that interface of unfair competition law and IP, which is underappreciated, that sometimes IP can be exhaustive statement on the free riding that is illegitimate. And I think hyperlinking by embedding is a very good example, though I see that in many countries that the Dutch way of thinking about this, that a copyright law cleared that, also for unfair competition law is not necessarily there. But I think it's wrong as a matter of secondary law. That's my personal view, but there are some Central European countries dealing with this, saying that, no, unfair competition law is untouched. So, this is certainly not like a dominant view.
So, it's 5:22, so we were 2 minutes late.
Oh, there's the grumpy cat again.
The
Sorry,
grumpy cat, yeah.
I meant to say thank you, of course.
So 2 minutes late, but more or less there.
Thank you very much. I would like to thank this great panel. Also, I would like to thank all speakers of this afternoon, because I think we profited from exchange of these views, and we had a very lively discussion under the lead of Fabio. Thank you, Fabio, for your efforts. We appreciate that all speakers could come and share their knowledge. So I'm repeat Fabio's mention that I'm encouraging those who are not members of ECTA yet to become members of ECTA, because these lively discussions definitely will continue in our next annual meeting in Athens. You all have the brochures, so we will definitely cover also the copyright issues. So thank you very much, and looking forward to see you in another event.
Yep, you're very welcome.